already. So, with that we will move to the next key term. What is the next key term? Judicial review. So, we will try to understand that one by one very quickly. So, the first thing that you are going to understand is judicial review. So, we have already seen what is judicial review. Who exercise the power of judicial review? Judicial review is a power of the judiciary. It is the judiciary which is the power, especially the Supreme Court and High Court uses power of judicial review. And what do they review? It is a power of the judiciary to review what? It is the power of the judiciary to review the actions of both the legislature as well as the executives. They review the actions of both the legislature as well as the executive, and to what extent they review? What is the parameter based on which they review the actions of the legislature and the executive? Whether the actions of the legislature and executive is in consonance with the constitution, or in other words, if their actions are violative of the constitution, if it is in violation of the constitution, those actions can be declared to be unconstitutional. So, because the judiciary also does not have an extraordinary power, or judiciary does not have what is called as a complete uncontrolled power, because the judiciary also derives the powers from where? From the Constitution of India. So, therefore, the judiciary will review the actions of the legislature and executive, whether their actions are in line with the provisions of the constitution. And if it is not in line with the provisions of the constitution, then such a action can be declared to be void, that is illegal. Be it a law that is made by the legislature, be it an implementation of the law which is done by the executive, everything has to be strictly in line with what? Strictly in line with the constitution. Okay, now just tell me, using the power of judicial review, can the judiciary strike down a law which is bad in character? A law which is bad in character, just the law is bad in the opinion of judiciary, or in the opinion of judiciary the law is not very appropriate, that the judiciary is trying to question the wisdom of the legislature. Is that a ground on which the judiciary can declare a law to be illegal using its power of judicial review? Just try to think about it. I am saying bad, but I am not saying that it is in violation of the constitution. That is the question that you will have to understand. Now, say a law may be bad in the opinion of judiciary, but it is not in violation of the constitution. Can such a law be declared to be unconstitutional by the courts using its power of judicial review? Is that possible? How many of you think yes? How many of you think no, it is not possible? Now, try to understand, the judiciary is nobody to declare a law unconstitutional because it is bad, because they do not like it, unless and until it is in violation of the constitution, because the judicial review is strictly done in line with what? In line with the principles in the constitution. If they can come to a conclusion and if they can give a conclusive judgment that it is in violation of the constitution, then only they can declare it to be unconstitutional. Is that clear to all of you? So, for example, some of the judges might feel that the reservation is not good, but we will have to see whether the reservation is in violation of the constitution or not. Does the constitution allows for it? So, that is what is very important. So, unless and until something is in violation of the constitution, such actions of the legislature and the executive cannot be declared to be invalid. That is basically what is the power of judicial review. Okay, so please, what is the next term after judicial review? Amendment. Okay, this is why I am doing this particular classes. These are all certain things I will repeatedly use as I will proceed. So, therefore, you should have an understanding. Later, I may not explain what is judicial review. I might just use the word judicial review. You should be in a position to comprehend this. I might use the word amendment. You should be in a position to understand what do I mean by amendment. So, what do I mean by what does it mean by amendment? It is generally, amendment means change. But with regard to the subject Indian polity, amendment would mean amendment to the constitution, that is changes in the constitution. That is the general way that we refer is amendment to the constitution. Now, can anyone tell me who is authority under the constitution of India to amend the constitution? Who has authority to amend the constitution? The only authority to amend the constitution of India is the parliament. So, try to remember this. The only word is very, very important. Parliament is the only authority to amend the constitution, and this power is given to the parliament by way of a particular article in the constitution, a particular rule in the constitution. Does anyone know which article is giving this power to the parliament? Very good. It is article 368 of the constitution that is giving the power to the parliament to amend the constitution. And since the commencement of the constitution till this point of time, 106 amendments has been done under article 368. So, how many amendments has been done? 106 constitutional amendment, or 106 times the constitution has been amended under article 368, and the latest one has been done in the year 2024. That means starting the first constitutional amendment act in the year 1951 until this point of time, 106 constitutional amendments has been carried out, and all these amendments has been done by the parliament by virtue of the power that is given to the parliament under article 368 of the constitution. So, who is the only authority to amend the constitution? Parliament, but we do have state legislature also, that is also legislature. Can the state legislature will have the power to amend the constitution? They have no power to amend the constitution. Who has the only power to amend the constitution? Only the parliament. But however, try to understand. I said one of the feature of the Indian constitution is both rigid as well as flexible, if you remember. Did we see that? And what is the meaning when I said that the constitution of India is both rigid as well as flexible? That some of the provisions are difficult to amend and some of the provisions are easy to amend. So therefore, you will have to understand the constitution of India was not amended only 106 times. In fact, it was amended more than 106 times. But under article 368, it was amended only 106 times. That means try to understand, whenever the constitution is to be amended by under article 368, it has to be done by a special majority or a special procedure. Right now, try to understand a special procedure, a complex procedure which is done by a special majority. And what is a special majority? I will explain subsequently. After I complete all those things, I will take up all the majorities, I will explain you. But right now, try to understand, whenever the constitution is to be amended under article 368, it requires a special majority, or in other words, it is done by a special procedure. And whenever I said special majority or special procedure, the implied understanding is this is a complex process. This process is not easy. So that means, while the constitution can be amended by whom? Only by the parliament. But if the parliament is to amend the constitution under article 368, it is a very complex process. That is a very rigid process. And how many times this power has been used by the parliament by under article 368? 106 times. But it is not necessary that all the provisions in the constitution has to be amended by the parliament only under article 368. Outside article 368 also, the parliament has the power to amend the constitution. But under article 368, how many times this power has been exercised? 106 times. While when the parliament exercises a power under article 368, it requires a special majority, it is a rigid process. But if the parliament amends the constitution outside article 368, then it requires only a simple majority or a simple procedure. So this is under article 368, but the amendment can also be done outside article 368. And in that particular case, what is the procedure? It is a simple majority or a simple procedure. Right now, I have an understanding it is a simple procedure, but it is done by a simple majority. I will let you know as to what is a simple majority. But however, under article 368, how many times the constitution has been amended? 106 times. But it is not necessary that always the constitution is amended only under article 368. But however, you will have to keep this in your mind, the numbering system that we follow right after the commencement of the constitution till this point of time, this numbering is followed only when the constitution is amended under article 368. If the constitution is amended outside article 368, that is by simple majority, those things are not numbered. And what is numbered is only whatever is done under article 368 of the constitution. So that is why we have already read that one of the features of the Indian constitution, it is both rigid as well as flexible. When it is rigid, when the constitution is amended under article 368. When it is flexible, when it is done outside article 368. So therefore, you can ask me a question. So how this power is exercised by the parliament? When do the parliament know when the constitution has to be amended under article 368? And when the parliament can do it outside article 368? Is it for the parliament to decide? No, the parliament has no authority to decide. These are all mentioned in the constitution itself. The constitution itself says that when the parliament has to do it under article 368 and when the parliament can do it outside article 368, or in other words, when the parliament has to follow the special procedure, when the parliament can follow the simple majority or the simple procedure. This information is also given where? In the constitution itself. That as we will proceed, we will try to understand. So as of now, the basic understanding you should have is, what does it mean by amendment? Amendment means changes to the constitution. And who is authority to amend the constitution? The parliament. And the parliament can do so under article 368, which requires what is called as a special majority. The parliament can do it outside article 368 also. In that particular case, what is a majority that is required? Simple majority. Is that clear? Please come to the next topic. What is the next topic? Rights. So, we have learned yesterday itself. So, can you just recollect the concept of rights? What is rights? Rights are basically nothing but claims and entitlements. Claims and entitlements. These are all the claims and entitlements that we possess as a citizen, not necessarily only against the state, sometimes even against a private individual also. Say for example, as a Consumer Protection Act which gives you the right, it is not necessary that you always consume the goods and services from the state. It can be from a private player also. Do you consume any goods and services from a private player? Can you give an example? Say for example, you go and purchase an Apple iPhone. The government is not selling this Apple iPhone. Who is selling this Apple iPhone? A private player, a distributor who is selling it is a private player. But there also you are protected through what is called as consumer rights. But there are certain rights where your claim is against the state, especially the fundamental rights. So, it is not necessary that it is only always against the state, but wherever there is a right means that you have certain claims and entitlements, and you are eligible to protect such claims and entitlements. And whenever these claims and entitlements are violated, then you can also approach the courts. And whenever the right is violated, you will have to keep it in your mind. Whenever the right is violated, what follows? We can seek what is called as remedy. We can seek what is called as remedy. And remedy means we can go to the courts and we can seek the remedy in case of violation of the rights. So, rights basically means entitlements and claims of every individual. But however, I can broadly classify these rights into three types of rights. All the three types of rights are legally enforceable. What are the three types of rights? First and foremost of all the types of rights. So, let me try to put this also, the types of rights. One is the fundamental rights. One is the fundamental rights. And what do you understand by fundamental rights? These are all rights which are mentioned in part 3 of the constitution. That means not just in the constitution, in the constitution where they are mentioned, they are all mentioned in part 3 of the constitution. So, any right that comes from part 3 of the constitution, they are all called as the fundamental rights. Now, why these rights are placed in the part 3 of the constitution? In the last class you have seen an explanation. Why they are placed in part 3 of the constitution? Because these are all the minimal rights which are essential for a dignified human survival, without which the members of the Constituent Assembly thought the individuals will not be able to have a dignified life, the individuals will not be able to empower themselves, develop themselves. The minimal essential rights are placed there. So, these are all called as fundamental rights. So, one type of right is the fundamental rights, then the next is constitutional rights. Constitutional rights. So, what do you understand by constitutional rights? Which are all guaranteed in the constitution except the fundamental rights, because in fact even the fundamental right is also a constitutional right, because where does a fundamental right come from? From the constitution, but the most appropriate expression for that is fundamental rights. So, therefore, any right which is given in the constitution except those in part 3 of the constitution, they all would be considered to be what is called as the constitutional rights. Suppose if the idea of fundamental right, the option fundamental right is not given, but only option that is given is constitutional rights, then in that particular case the fundamental rights are also coming from the constitution. But suppose if fundamental right is given, then what would be the most appropriate thing? It is a fundamental right. So, therefore, what is constitutional rights? These are all rights which is guaranteed in the constitution, but outside part 3 of the constitution. Can you give me an example of rights guaranteed in the constitution, but outside part 3 of the constitution? Very good. So, one, I at least give couple of examples. One is right to property. Right to property. So, today right to property is mentioned where? Article 300A. Right to vote. Article 326, which provides for adult suffrage. that is your right to vote. So these are all constitutionally guaranteed. So these are all considered to be what is called as constitutional rights. But these rights are not there in part 3 of the constitution. Okay, suppose if the fundamental right is violated, can you approach the courts? What about the constitutional rights? When they are violated, can you approach the courts? But in both the cases, when your claims and entitlements are violated, when that is breached, you have a remedy of seeking, you have a remedy that you can approach the courts. But what is the difference between when the fundamental right is violated and when a constitutional right is violated? In the case of fundamental right, then you can directly approach the Supreme Court of India. But in case of constitutional right, you cannot directly approach the Supreme Court of India. You can approach the Supreme Court only by going through the ordinary hierarchy of courts. You will not be able to directly approach the Supreme Court. Now, why this distinction between fundamental right and constitutional right? Because in the opinion of the Constituent Assembly, these rights are more important. And because these rights are more important, an immediate remedy has to be given. An immediate remedy will come from where? From the highest court of the country. But otherwise, in this particular case, it's not so urgent and so immediate. So therefore, you can follow the ordinary hierarchy of courts. And that's the distinction between what is called as the fundamental rights and constitutional rights. Alright, we have understood fundamental right, constitutional right. Let me complete. Now, the third type of right is what is called as legal rights. Legal rights. So, what do you understand by legal rights? Fundamental rights, these are rights which is there in the part 3 of the constitution, which flow from where? Part 3 of the constitution. What is a constitutional right? These are rights that flow from the constitution, but not in part 3 of the constitution, outside part 3, but in the constitution. Now, what is a legal right? These are all rights that flow from the ordinary legislations or the ordinary laws that is made by the parliament and the state legislature. These are all rights that is flowing from the ordinary laws or protected by the ordinary laws. So, these are all what is called as legal rights. Say for example, Consumer Protection Act is there. Consumer Protection Act. Consumer Protection Act is there. This Consumer Protection Act is neither mentioned in the part 3 of the constitution nor it is mentioned where? It is mentioned in the any of the provisions in the constitution. But however, we do have as a consumer, we exercise what is called as the consumer protection rights. But from where we get those rights? From the Consumer Protection Act. So, because we get this right from the Consumer Protection Act, but this is not the constitution, this is not part 3 of the constitution, this is an ordinary law. If any ordinary law confers any right upon you, and such a right is what is called as what? Legal rights, or it is also called as statutory rights. So, do not get confused if it is mentioned as statutory rights, because the law is also called as statute. So, therefore, any right that is flowing from a statute is what is called as statutory rights. So, normally they do not use this expression, but in case if they use this expression, do not get confused. Statutory rights or ordinary legal rights. Okay, now I told in the last class that right to property is what? What type of right? It is, as of now, I told you to remember it as a constitutional right. But I also said it can also qualify as what is called as a legal right. Now, how it can qualify as a legal right also? Do not get confused. If in the UPSC examination, if the option is given, right to property is what type of right? If they are giving legal right, fundamental right, none of the above, whatever it is, then the right option would be constitutional, it will be legal right. But if they give both constitutional and legal right, then the most appropriate would be constitutional right. But if the constitutional right is not given, then the legal right is also correct. Why? You will have to understand, where does right to property come from? It comes from Article 300A in the Constitution. So, what is Article 300A of the Constitution is saying? No person shall be deprived. Try to understand. What is the wordings of Article 300A? No person shall be deprived of their right to property except by an authority of law. That is the expression that is given under Article 300A of the Constitution. I am just repeating it again. No person shall be deprived of their right to property except by an authority of law. So, does anyone comprehend the meaning of this particular statement? That no person shall be deprived of the right to property except by an authority of law. That means, try to understand, the right to property is not an absolute right. Right to property, though protected and guaranteed in the Constitution, the right to property, the property of a private individual can be taken away. And who can take away the private property of an individual? The state can take away the private property of an individual. So, normally the state, if they want, they can take away the private property of an individual for public good. So, for example, you own an agricultural land, but that agricultural land is to be required by the state, or if the state wanted to purchase that agricultural land in order to build a national highway or in order to build a hospital which is serve a public good, then the state can purchase, acquire that private property, and they can compulsorily acquire that private property also. But however, what is Article 300A is saying that no person shall be deprived of the right to property except by an authority of law. That means the state cannot arbitrarily, compulsorily acquire a private property. If the state is to acquire a private property, there should be a law, and that law should allow the state to acquire that particular private property. So, in line with the procedure that is given in that particular law, the private property can be acquired by the state. So, therefore, who is protecting the private property in this particular case? The law that is enacted by the parliament or the law that is enacted by the state legislature is protecting the private property, because as per the law, the private property can be acquired, not in violation of that particular law. So, therefore, in this particular case, who is protecting the private property? The law is protecting. So, therefore, it can also be considered to be what is called as legal right. So, therefore, if an option comes whether it is a legal right, that is also true. But if a constitutional right is given, then the most appropriate thing would be what is called as a constitutional right. Okay, I'll give one more example here. Can you give me an example of other legal rights? How many of you heard about the Criminal Procedure Code, CRPC? The CRPC gives you the right to file an FIR. So, if there is any offence that is criminal offence that is committed against you, then it is your right to file an FIR. That is your legal right. The police cannot deny filing an FIR, because the right is given by way of what is called as a Criminal Procedure Code, which has been renamed recently. Does anyone know what is the renamed version? So one is the IPC, and then other is CRPC and the Indian Evidence Act. All the three things has been renamed, but for the purpose of examination, if you want, you can continue to use this for some more time. You have that particular liberty. So, the right to file FIR is again your legal right. Can you just come up with any of the other legal rights? Very good. Special Marriage Act, right to dissolve your marriage, right to seek maintenance in case of divorce. These are all rights which is given under the, not only the Special Marriage Act, in fact under the Hindu Marriage Act also, and in fact under the various other personal laws as well. The right to seek maintenance, right to seek your rights in case, your spousal rights in case of marriages. These are all part of what is called as legal rights. These are all coming by the ordinary laws of the land. Yes, do you have an example? RTI is considered to be a legal right. Although the Supreme Court of India way back in some of the cases recognized when there was no Right to Information Act, they said that it is implied under Article 19 of the Constitution. But then subsequently Right to Information Act 2005 has been passed. So, now it is considered to be more of a legal right. Right to education is a fundamental right, because it is directly given in the Constitution under Article 21A, but how that gets implemented is done by the Right to Education Act. But the right is flowing from directly Part 3 of the Constitution. It is a fundamental right. Okay. Okay, so this is what you have to understand. So, rights in general means claims and entitlements, and broadly how the rights can be classified. These are all the rights that is legally enforceable. Apart from that, we also call something as natural rights, something as human rights. They have no legal enforceability. They are all only philosophical construct. So, in our country, as per the constitution, as per the laws in our country, what type of rights can be enforced? Only these three rights, that is fundamental right, then you have what is called as constitutional right, and then you have what is called as the legal rights. So, what is the difference between a fundamental right and a constitutional right? Fundamental right only in part 3 of the constitution. What about constitutional right? Except part 3 anywhere in the constitution. What is a legal right? The right flowing from the ordinary laws of the land. It can be a law made by the parliament or by state legislature, does not matter. So, those type of rights is what is called as legal rights. Alright, so what is the next topic? Okay, somebody wanted to ask me doubt. What is your doubt? Is it clarified now? What is the name? What is the doubt? Clarified? It is not a fundamental right. Why means the Constituent Assembly has not decided it to be a fundamental right. I cannot answer why it is not a fundamental right, because they thought that although this right is so important, but it is not as important as that of the other fundamental rights. So, therefore, it is constitutionally protected. Okay. Okay, so please come to the next topic. What is the next topic? Writs. Okay. So have you ever heard of this word writs? Writs are nothing but directives. Okay, I have used this word directives earlier also, but as a part of the directive principles of state policy. And when I was discussing about the directive principles of state policy, when I was talking about the writs, when I was talking about the directive principles of state policy, I told directives. What those directives mean in case of directive principles of state policy? Those are directives to the whom? Whom these directives are given in the constitution. These are directives to the state. And the idea is if the state implement these directives, then it can automatically lead to what is called as a welfare state. But here the directives means these are directives which are issued by the courts. Writs means basically what? These are directives which is issued by whom? These are directives issued by courts. These are directives issued by the courts, and why the courts would issue these directives? The courts would issue these directives whenever the fundamental rights of the individuals are violated. Suppose if my fundamental right is violated, can I approach the court? I will bring it to the notice of the court that my fundamental right is violated. Say for example, let us assume there is an arbitrary detention, the state arbitrarily detains me, and therefore my fundamental right is violated, and because my fundamental right is violated, I will bring it to the notice of the court. So immediately what the court will do is, the court will issue a direction to the state or whoever has violated my fundamental right as to why you have violated the fundamental right of the individual, and ask them to appear before the court. So that therefore the court can look into this particular matter. And if the court is convinced, yes, there is a violation of fundamental right, then the court will provide a remedy to me. So this is basically what is called as writs. So writs are a special powers that is given to the courts under the constitution, especially to protect what? To protect the fundamental rights, or in case of violation of the fundamental right, to provide remedy to the affected individual. That is basically what is called as writs. In fact, the constitution empowers the Supreme Court and the High Courts in our country to issue 5 types of writs in case of violation of the fundamental rights. And you know which article is empowering the Supreme Court to issue writs? Article 32 of the constitution is empowering the Supreme Court to issue writs. Article 32 is empowering only the Supreme Court to issue the writs only in case of violation of the fundamental rights. And what type of writs they can issue? The Supreme Court under Article 32 of the constitution can issue 5 types of writs. So does anyone know what are the 5 types of writs? Don't make it very complex. I am not going to explain the writs because I will explain the writs when I take up the fundamental rights, but just know the type of writs right now. Just remember the writs by name. So what are the 5 types of writs that the Supreme Court can issue under Article 32? They can issue a writ of habeas corpus or habeas corpus. Does anyone know what are the other types of writs? Mandamus, very good. They can issue writ of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. These are the 5 types of writs that can be issued by the Supreme Court, and the type of writ that will be issued by the Supreme Court depending upon the type of violation of the fundamental rights, because we do have number of fundamental rights. So it is not that in all the cases the same writ will be issued. The court will decide what writ to issue depending upon which fundamental right is violated. So accordingly the court will issue the writs. But in general, what are the different types of writs that can be issued by the Supreme Court? The 5 types of writs. Now the question is it only the Supreme Court that can issue writs for the violation of fundamental rights? No, the High Courts can also issue all these 5 writs in case of violation of the fundamental rights. But however, which article in the constitution is empowering the High Courts to issue the writs? It is Article 226 of the constitution. So different article is empowering both the courts. So in case of Supreme Court, it is Article 32, and in case of High Courts, it is Article 226. So under Article 226, the High Courts can also issue all the 5 types of writs, and the Supreme Court can also issue all the 5 types of writs under Article 32. So it is for us as an individual to decide where we wanted to go, whether we wanted to go to the Supreme Court or whether we wanted to go to the High Court in case of violation of the fundamental rights. Now tell me, why would you go to the High Court when we have an option of directly going to the Supreme Court? No. Just talk about the fundamental rights. I am just talking about the fundamental rights. I am not even talking about the legal rights. While your answer may not be wrong, but it is not relevant to what I am asking. Okay, now the question is, while both the Supreme Court and High Courts are empowered to issue writs in case of violation of the fundamental rights, assume that your fundamental right is violated, any fundamental right. So, when you have an option of going to the Supreme Court directly and seeking a remedy directly from the Supreme Court, why would the individuals go to High Court? Why do you think this option of going to the High Court is given? What is the logic behind that? That is the question. Well, the Supreme Court is a speedy justice. No, I am talking only about the fundamental right. I am not talking about any of the other rights. So, it is because of the logistical reasons, true. It is not that everyone is capable of going to the Supreme Court. It is very costly to go to the Supreme Court. He may not be able to travel to the Supreme Court to fight this particular case. He may not have the money to go to the Supreme Court. But High Court is more accessible to that particular individual in whichever state he is. So, therefore, just because of the logistical issues, because of lack of resources, the individual right should not be curtailed in any way. Therefore, they can approach the High Court also. But logically, going to the Supreme Court means immediate remedy. But going to the Supreme Court is not an easy thing. How many of you ever have an experience of fighting a case in the Supreme Court? Does anyone have an experience of fighting a case in the Supreme Court? Okay, at least in the high courts in our country, in any of the subordinate courts. So, if at all you do not have an experience, it is better that you have no experience in your entire lifetime, because once you start a case, the case will go for lifetime, unfortunately for the people who may not possess the resources. Do you know how much charge has been levied or charged by the senior advocates in Supreme Court if you have to engage a senior counsel in Supreme Court? Do you know? Of course, it may vary from case to case, but in general, even if you want to take someone who is a very decent lawyer, he is not a very big lawyer, a decent lawyer, he may charge you 2 to 3 lakhs per hearing. And you know how much time a hearing might hold? It may be less than 10 minutes, sometimes it is 2 minutes, sometimes it is 3 minutes. And you know how much hearing will happen before a case gets completed? The case may go on for a 10 years, 15 years. So, it is not possible humanly for an ordinary individual to fight a case in the Supreme Court, unless and until if there is some luck. It is very difficult unless until you have a backing of someone, or you have the resources to fight it, or someone who is having a legal background. It is extremely difficult to fight the cases, but yes, at least these are all guaranteed. So, that is the reason that sometimes they have to go to the high courts also. But yes, if they want to approach a Supreme Court, they can approach a Supreme Court also. What kind of, which court? I do not know. Which court is there in Dwarka? Of course, definitely not the High Court, because High Court is not there. Maybe a district court. And UPSC is not going to definitely ask that which court is there in Dwarka, so you do not have to worry about that. Okay. Okay, very good question. But all those things I'll discuss when I take up the fundamental rights in detail. But because you asked this particular question, your question is basically he is asking that is the locus standi mandatory when it comes to filing the writ? Or in other words, this question is that if somebody is getting arrested, is he himself have to file a petition in the court, or on his behalf somebody else can also file it? Can it be a public interest litigation also? Not for all the writs the locus standi is mandatory, but for certain writs the locus standi is mandatory. Locus standi means what is your standing, what is your right to fight this particular case. So, to answer this particular question very short, not for all the type of writs the locus standi is important. That means not in every type of writ you will have to personally file a petition. On your behalf somebody else can also file a petition, but in certain type of writs the locus standi is important. But I will discuss that when I take up the fundamental rights. If I start explaining, you will not understand. For which first I will have to make you understand what is locus standi, what is public interest litigation. Those are all part of the key terms which I will subsequently discuss. So, once I will make you understand all those things, then I will do all this when I take up the fundamental rights. What is the next keyword? Nominal executive or de jure executive. Who is a nominal executive in our country? President at the union level, and at the state level who is the nominal executive? The problem is when the nominal executive try to become a real executive. The constitution does not envisage the president to be a real executive, it is only a nominal executive or he or she is a de jure executive. What does you mean nominal or de jure executive? That means for namesake. For namesake, or they are only a formal head. Formally, they are considered to be the head of the state. But however, the real powers are not vested in the nominal executive or the de jure executive. So that is basically what is called as nominal executive. That is only for the namesake, or only formally they are considered to be the head of the executives. But however, the real executive in our country at the union level. So when you talk of nominal executive at the union level, it is a president who is the nominal executive. For the union executive, it is the president who is the nominal executive. But who is the real executive when it comes to the? Who is the real executive when it comes to the union? It is not only the prime minister, it is a prime minister and the council of ministers. But however, it depends upon the personality of the prime minister. Suppose if the prime minister is more democratic, then probably all the ministers will exercise power. But if the prime minister is more authoritarian in nature, so the prime minister might exercise all such powers. But the real executive as per the constitution is the prime minister and the council of ministers. They are the real executive. And who is the normal executive? It is the president. That is only for namesake. That is the understanding you should have. And at the state level, similarly, who is the normal executive? It is a governor who is a normal executive. And who is the real executive there? The chief minister and the council of ministers. Okay. And how they are normal executive and how they are real executive, which we will understand when I take up the executive. But right now, the idea is when I talk of, say for example, tomorrow when I discuss a particular concept where I use a word de jure executive or a normal executive, you should be in a position to understand what does it mean by normal executive. All right. What is the next keyword? Electoral college. How many of you come across this particular word, electoral college? How many of you come across this particular word, electoral college? Okay, so what is this electoral college? To put it in a very simple way, electoral college is nothing but a body of people. It consists of a group of people who are eligible to vote in elections. Whenever I use a word in the context of polity, when I use the word electoral college, what is the understanding you should have? Electoral college means a body of people or a group of people who are eligible to vote in elections, in certain type of elections. That means under our constitution, if you see, there are different types of electoral college for different elections. Not the electoral college is same for all the types of elections. The electoral college will vary for different types of elections. So in general, it is what? It is a group of people. It's a group of people who are eligible to vote. Who are eligible to vote. Only the people who are part of the electoral college, only they will have the right to vote. The others will not have the right to participate in the elections. And that's basically what is called as electoral college. That means now try to answer my question. There are different types of elections that is there in our country. So although you don't have to remember who are all part of the electoral college presently, but can you just recollect whatever you know and tell me what are the different types of elections under the constitution? What are all the posts for which the election happens in our country? Very good. For the president, we do have elections. Okay. Elections. Okay, we have president election then. Okay, very good. Vice president. Vice president, very good. Speaker, where? Speaker. Speaker is not for the parliament. Speaker is specifically to the Lok Sabha. Okay. Speaker Lok Sabha, and I will also put the legislative assembly in the states, because both in case of the Lok Sabha as well as in the legislative assemblies in the state, the presiding officer is called as the speaker. What else? What else elections happen under the constitution? Very good. So we also have what is called as deputy speaker, both in case of Lok Sabha and the legislative assembly. No, the deputy speaker is not for the Rajya Sabha. Speaker is always for whom? Speaker is always for Lok Sabha and to the legislative assembly. Deputy speaker, who is a deputy to the speaker, is only to the Lok Sabha and the legislative assembly in the states. What about that? For the Rajya Sabha, who is elected? The chairman is not elected. The chairman is an ex officio chairman. Ex officio is also a keyword that I will explain. But try to remember right now, whoever is the Vice President of India will automatically become the chairman. There is no election to the chairman of Rajya Sabha. So therefore, there is no electoral college because there is no election in the first place. But yes, the deputy chairman is elected. Who is the chairman of Rajya Sabha? It is a vice president. Whoever is elected as a vice president automatically becomes the chairman of Rajya Sabha. Presently, who is the vice president of India? Mr. Jagdeep Dhankar, who is also the chairman Rajya Sabha, but he is not elected as a chairman Rajya Sabha. Because he is a vice president of India, because he is elected as a vice president of India, he automatically becomes a chairman of Rajya Sabha, which is also called as ex officio chairman. Have you ever heard of the word ex officio chairman? Ex officio means by virtue of one's status or by virtue of one's position, he automatically occupies certain other position. That is basically what is called as ex officio, which anyways I will explain. But here, coming to the discussion that you are having, there is no election to the chairman. But what about the deputy chairman in case of Rajya Sabha? The deputy chairman is elected. So, deputy chairman in case of Rajya Sabha. And what about the chairman in case of the legislative councils? In case if a state is having a legislative council, in the last class I told that while in case of parliament, two houses are mandatory, that is both Lok Sabha and Rajya Sabha. But what about in case of the states? Is it mandatory to have both the houses? It is not mandatory. But what is mandatory in case of the states? Legislative assembly is mandatory. What about legislative council? Legislative council is optional. It is for the states to have or not to have it. But if any state is having a legislative council, then there should be a chairman to the legislative council. Is there an election to the chairman of the legislative council? Yes, while in case of the legislative council, the chairman is elected, both the chairman and the deputy chairman. So, let us put chairman and deputy chairman in case of the legislative council. What else? Who else is elected? MPs both in case of Lok Sabha and Rajya Sabha. Very good. Lok Sabha and Rajya Sabha. Then MLAs and MLCs. MLA and MLCs. Who else? Okay, as far as you can know, these are all something that you can recollect. So, all these people are elected. Does it mean that for all these elections people vote? Now, the question, now we are coming to the concept of what is called as electoral college. Okay, now all these dignitaries are elected, but who is voting in all these elections? That is a question. Now, therefore, you should understand the concept of electoral college. The electoral college for electing different authorities is different under the Constitution of India. The only thing when you talk of the people, we have talked about the universal adult suffrage, where people will have, anyone who is an adult individual who has attained 18 years of age shall have the right to vote. That is primarily only to the election to the legislative assembly, that is MLAs, and to the Lok Sabha, while the people directly do not have the right to vote in the other areas. That means for different areas there are different electoral college. For the president, who will have the right to vote? Do you think that we will have the right to vote in the president's election? We do not have the right to vote in the president election. For the president election, there is a separate set of electoral college. Only those who qualify under the electoral college will have the right to vote. For the vice president, there is a separate set of electoral college. To elect the speaker in case of Lok Sabha, there is a separate electoral college. To elect the deputy speaker in Lok Sabha, there is a separate electoral college. So, therefore, I am not asking you to remember as to who constitute the electoral college for electing these people, which we will subsequently discuss when I take up the different topics. But right now, we should have an understanding of the definition of what is an electoral college. What is electoral college? Electoral college means a body of people or a group of people who will exercise the right to vote. And for different elections, there can be different sets of electoral college. Now, based on all these things, can anyone tell me who constitute the electoral college when it comes to the election to the Lok Sabha? Who will constitute the electoral college when it comes to election to the Lok Sabha? All the eligible voters who attained 18 years of age. So, that is the electoral college. But that is not the electoral college when it comes to what? The electing the president or the speaker. Who constitute the electoral college when it comes to electing the members of the legislative assembly? Who constitute the electoral college? all the eligible voters who have attained 18 years of age, but who are resident in that particular state. While for the Lok Sabha it is anywhere in India, but for in case of the Legislative Assembly it is only in that particular state. So, similarly for electing different authorities, different electoral college is there. But the point right now for you is you should understand the definition of electoral college. That means these are all a body of people or a group of people who are eligible to vote in certain elections. Only that is what is called as electoral college. What is electoral college for the president, vice president? When I take up the topic of president, I will explain you who are all part of the electoral college. But at that time, I will not explain you what is electoral college in the first place. I will tell you that these are all people who are part of the electoral college. Okay. So, that is the reason I am explaining the concept of electoral college. What is the next topic? First past the post system, again a very important topic. First past the post. You know, this is a system that is followed in certain election to decide the winner of the election. And basically there are broadly under the different constitutions of the world, broadly there are two types of methods that is used to decide the winner in the election. One is the first past the post system and another is proportional representation. And in India largely we use a system of first past the post system. In certain places we also use a proportional representation. So, what exactly is this first past the post system? Now, first past the post system is a simplest way that is used to calculate, a simplest method or a way to decide as to who is the winner in the election. And it is a first past the post system we use in election to the Lok Sabha. It is a first past the post system, it is a method that we use in election to the legislative assemblies. In both the cases we use what is called as a first past the post system. Now, what is a first past the post system? To put it in a very simple way, suppose let us assume there is a 100-meter running race. Let us assume a 100-meter running race is there. Suppose there are 4 participants who are contesting this 100-meter race. So, let us assume contestant 1, 2, 3, 4 are participating in this race. So, who will be the winner of this particular race? As far as whatever knowledge that you have based on the rules of 100-meter race, who would be declared to be the winner of the race? Whoever crosses first. Whoever crosses first is the winner. It does not matter whether he crosses in 20 seconds, 30 seconds, 50 seconds, 1 hour, it does not matter. But who is the winner of this particular race? Whoever crosses the post before others. That means one of them has to make sure that he is crossing the post before the others, then he would be the winner. Okay, instead of this particular rule, let us change the rule now. The rule of this particular race is anybody who crosses the post before 10 seconds. Then what will happen in this particular case? There is a possibility nobody can win also, because before 10 seconds means Usain Bolt is only one person who has done that before 10 seconds, maybe few other individuals in the entire history. Before 10 seconds, nobody will be able to cross, or might be possible everybody is crossing. Nobody is crossing also, no winner, everybody crossing, all are winner, that is also a problem. That is why the simplest method that we follow right now in election is what is called as first past the post system. To put it in elections, let us assume that there is a constituency. In this constituency, let us assume there are 100 voters. That means when I say 100 voters, who are all there in the electoral college? When I say 100 voters, only these 100 voters have the right to vote. That means electoral college members, how many members are there in the electoral college? 100 members. Suppose let us assume there are 4 candidates contesting the election. A, and then you have B, and then you have C, and then you have D. So, now let us assume A has got 30%, B has got 20%. Okay, let me just redraw this a little. D has got 40%, 40, 30, 70, and C has got 10%. That means out of 100 votes, 4 people contesting the election, D has secured 40 votes, A has secured 30 votes, B has secured 20 votes, and C has secured 10 votes. Who would be the winner of this election if you apply the first past the post system? Who is the winner? But none of them has secured the majority. What would be the majority of 100 voters? 50 is not majority, 51, that is more than 50% is what is majority always. None of them has secured the majority, but still do you think A is a winner? How many of you think A is a winner in this case? Nobody has secured the majority. When you apply the principle of first past the post system, there is no need for what is called as majority. When you apply the principle of first past the post system, the winner has to make sure that he gets more number of votes than the other candidates. So, anyone who secures more number of votes than the other candidates, then he automatically becomes a winner even if he has not secured what is called as a majority. So, based on the principle of first past the post system, who is a winner in this election? D has got 40 votes, is a winner in the election. That's basically what is called as a first past the post system. Is that clear? So, first past the post system does not require any majority. First past the post system only needs what? That the winner has to secure more votes than the other candidates who are contesting the election. Then in that particular case, the winner is someone who secures the more number of votes, and there is no need to secure the majority. This is first past the post system. And where do you use this first past the post system? We use this first past the post system in the election to the Lok Sabha, and we also use the first past the post system in election to the Legislative Assembly to elect the MLAs in our country. First past the post system. To elect MPs to Lok Sabha, we use first past the post system. Is that clear to all of you what is first past the post system? And you can ask me that they are not even getting the majority. Why they would be the winner? Because this is the simplest way of electing the winner. And India is a very big country, too many population. So, in order to reduce the complexity of the election process, the Constituent Assembly thought that the winner, when it comes to election to the Lok Sabha and to the Legislative Assembly, which principle is followed? First past the post system. And in the first past the post system, anyone who secures more number of votes than the other candidates would be the winner, even if he has not got what is called as the majority. So, it is not only in case wherever there is a first past the post system, this is the principle. And there is another method of getting the winner, that is what is called as proportional representation. Have you ever thought, before I get into proportional representation, have you ever thought that certain parties in the election to the Lok Sabha, of the total vote share, they got 20% of the votes? Say for example, in one of the elections, I think the previous Lok Sabha elections, the Bahujan Samajwadi Party, of all the votes that is polled in the state of Uttar Pradesh, they secured 20% of the votes. That means if 1 lakh voters are voting, how much vote is secured by the Bahujan Samajwadi Party? 20,000 votes. And if it is 1 crore, then it is 20 lakh votes. But they have not even one single seat. They are not even one single seat, but they have got so many votes. This is because of the reason that the election is based on the first past the post system. That means in none of the constituency they have got more number of votes than the other candidates. Maybe they are second, maybe they are third, but they have not secured the highest number of votes in any of the constituency. So, therefore, in the first past the post system, try to understand the number of seats a party is getting in the Lok Sabha or in the Legislative Assembly is not exactly reflecting the percentage of votes that they have got. Is that clear to all of you? That is also the reason, if you see in the 17th Lok Sabha, not in the 18th Lok Sabha, the previous election, in the 17th Lok Sabha, BJP has got almost 36% of the votes, not more than that. Of all the votes they have got, how much percentage of votes they have secured? 36% of the vote, but that translated into 60% of the seats in the Lok Sabha. That is because wherever they have won with a few margin, but ultimately they have won. That is because of the first past the post system. As an alternative to the first past the post system, some of the countries do follow what is called as proportional representation. Now, what is the biggest advantage of first past the post system? The biggest advantage of first past the post system is it is easier to come out with a winner, and it reduces the complexity in the election process and declaring the results. But what is the drawback of the first past the post system? It does not exactly reflect the will of the people, because 20% of the votes not translating even into a single seat, 36% of the vote translating into 60% of the seats. So, it does not exactly reflect the will of the people, or it is not proportionately reflecting the number of votes into number of seats. And that is why some of the constitution they are also following what is called as proportional representation. What happens in a proportional representation? In proportional representation, let us again take this example. Suppose let us assume there are 4 parties instead of individuals. There are 4 parties, let us assume party A, B, C and D. So, party A, let us assume 40% votes, party B, let us assume 20% votes, party C 25% votes, party C just for the example. So, it is A, B, C, D, let me make it 25 and let us assume 15%. I think 100 is over, 40, 60, okay, 25. Let us assume there are 4 parties. In proportional representation, what happens wherever there is a system of proportional representation, instead of the first past the post system, we as an individual will not vote to the candidates. To whom we will vote? We will vote to the party. So, instead of the candidates, we will vote to the party. Suppose let us assume party A. So, when I go to vote, I will have 4 parties and I can vote to any of the party. So, in this way, let us assume A has got 40% votes, party A has got 40% votes, party B has got 20%, party C 25% and party D has got 15% of votes, and the total number of seats, let us assume, in the parliament in the respective country. Anyways, we are not following the system, India is not following it, but to make you understand as to what is proportional representation, let us assume that there are 100 seats in their respective parliament, whatever is the name of their parliament, because parliament is not the same name for all the countries. In India we call it parliament, in USA they call it as Congress, certain other countries call it with a different name. So, whatever is the name that they have, let us assume there are 100 seats. Now, party A has got 40% of the votes. Because party A has got 40% of the votes, party A can nominate 40 members. So, how many members party A can nominate here? 40 members. And because party B has got 20% of the votes, how many candidates can be nominated by party B? 20. It is for the party to decide whom they want to nominate. And because party C has got 25% of the votes, 25 candidates can be nominated by C. So, this is in case of A, this is in case of B, this is in case of C, and last it is D in case of D. So, party D can nominate 15 members. So, this is basically what is called as proportional representation. What is the advantage of proportional representation here? That it exactly reflects the will of the people. Whatever is the will of the people is exactly reflecting. But what is the disadvantage of this? It is not only complex, but here nobody is having the majority. Now, to form the government you need majority. So, it is very difficult for someone to have the majority here, but it exactly reflects the will of the people. But what is the advantage of the first past the post system? The advantage is that it is easier to declare the winner and it will also help someone to form the majority. Say for example, in the 17th Lok Sabha, I said the BJP party has got only 36% of the vote, but that reflected in 60% of the seats. So, they were able to form the government with majority. So, therefore, both the systems have got certain advantages and disadvantages, but however, the Constituent Assembly has decided in favor of what? The first past the post system, because of the simplicity in deciding the winner when it comes to first past the post system. Is that clear to all of you? So, this is basically, but there are different types of proportional representation. This is basically what is called as party list system, but there are other forms of proportional representation, but I am not going deep into that because India does not follow the proportional representation when it comes to election to the Lok Sabha and the legislative assemblies. But for certain other elections, India does follow proportional representation. Can you tell me the elections where India follows the principle of proportional representation? In the election to the Rajya Sabha, in the election to the President of India, election to the Vice President, but they follow different proportional representation. But this is a general way of proportional representation, but the proportional representation that is used in the President, Vice President are little different, which I will explain subsequently. But largely when it comes to the elections in our country, we follow the principle of what is called as the first past the post system, except for election to the President, Vice President. In all other cases, we follow first past the post system. So, is it clear what is first past the post system? No, majority is a different thing. We are only talking about in a particular constituency. Say for example, out of 543 constituency, we are not talking about all the 543 constituency. In one particular constituency, in every constituency we will see the winner, and how that winner is decided in every constituency based on first past the post system. Clear? And then later we will see, after everybody getting elected, whether a particular party is having the majority. Still, if they are not able to get the majority, then also they will not be able to form the government. They might form a coalition government, or there will be a hung parliament. Nobody has a majority. That's a different issue. But from every constituency, how the winner is chosen, it is based on the first past the post system. So here there may not be any constituency in the first place. Only in the first past the post system there is need for constituency. Now try to understand, here there is no need for any constituency. The party will contest election for the entire country. The entire country, the people will come and vote. They will have to just see how many vote share they have got, and accordingly they will nominate such many, those many number of people depending upon the percentage of votes. Okay, so here there is no need for constituency in the first place in the proportional representation. Alright, is it clear to all of you? First past the post system and proportional representation. What is the next topic? Secret ballot. Okay, secret ballot. How many of you heard about this word secret ballot? How many of you voted in the elections? Lok Sabha election, Legislative Assembly elections, both? Both. Can you just describe that how you have voted? Of course, not to whom you have voted. So, just the process. Where did you go? How and how were you guided into the polling booth? Hmm. 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 Election Commission of India. Okay. Hmm. Okay. Okay. So it was an EVM, not the ballot paper. EVM. Okay. So EVM. So you went and cast your vote against the candidate to whom you want to vote. So wherever you cast the vote, do you think that it was in private, or others are able to know to whom you have exercised your vote? It was completely in private. So the system of voting which happens completely in private is what is called a secret ballot. That means nobody else will know about to whom you have exercised your vote. And such a type of voting is what is called a secret ballot. Is it clear to all of you? So secret ballot, to put it in a very simple way, that whatever the voting that you have done is completely done in private. Unless and until you reveal that to anyone, nobody else will come to know about it. Now, why do you think that the secret ballot is very, very important in a democracy? To prevent any form of coercion, because nobody should know to whom you have exercised your vote. So, therefore, nobody can threaten you with regard to the vote that you have exercised. And secret ballot ensures what is called as free and fair elections in our country. And that is why when it comes to the election to the Lok Sabha and to the Legislative Assembly, the system of elections that we follow is what is called as secret ballot. So therefore, try to understand, whenever you use the word secret ballot, what does it mean by secret ballot? That the voting is done in secrecy, the voting is done in private. So that is basically what is called as secret ballot. But however, not all the elections in our country is following the principle of what is called as secret ballot. Against the concept of secret ballot, we also have what is called as open ballot. Now, what do you mean by open ballot? Say for example, every weekend you have a test. Do you have a test this weekend? And from whatever I think we discussed, you may have a test. This, okay, geography test, not the polity. Okay, your geography test is there. Suppose let us assume next week, after this week, you have a polity test. Is it an objective test or a subjective test? First objective. Okay, suppose I am asking that how many of you do not want a test? Of course, although I don't have any authority to cancel that particular test, but I am just asking this particular question: how many of you wanted to cancel the test in the open class? And I wanted you to raise the hand. So some of you are raising the hand, and others are able to see this. So such type of voting is what is called as open ballot, and it is not done in what is called as secret. So can you give me an example of where open ballot happens? Where the open ballot happens? Okay, so the open ballot happens mostly in the parliament. In fact, it is not only for the elections. Say for example, when the bills are passed in the houses of the parliament, who is supposed to make laws in our country? The MPs have to make the laws. So whenever a bill is introduced in the house, and finally after the discussion is over, the presiding officer will ask how many of you support this particular bill. and then there may not be secret ballot. So the presiding officer will just ask you to ask the MPs to raise their hand, and the members who wanted to support the particular bill, they'll raise their hand and they'll say A. That means they are supporting this particular bill. And those who are not supporting the particular bill, they'll raise their hand and they'll say no. And this happens in an open ballot. So this is basically an open ballot. So most of the discussions and most of the things that is put to vote in the parliament, that happens by way of what is called as open ballot. But whereas when it comes to election to the Lok Sabha, legislative assemblies and all those things, they happen by way of what is called as secret ballot. So right now you don't have to worry about where there is a secret ballot, where there is an open ballot, but just try to understand the concept of what is open ballot and what is secret ballot. Is it clear to all of you? What is open ballot? What is secret ballot? Alright. So what is the next thing? Ex officio. Ex officio means, you can just write down one line if you want. Ex officio means by virtue of one's office or by virtue of one's status. Ex officio means by virtue of one's office or by virtue of one's status. Ex officio means by virtue of one's office or by virtue of one's status. That means he is not formally getting elected to any position, but by virtue of one's office or by virtue of one's position, he automatically occupies another office. That is basically what is called as ex officio, as in the case of vice president. So when I use the word vice president is ex officio chairman of Rajya Sabha. So what is your understanding when I say vice president is ex officio chairman of Rajya Sabha? Because he is the vice president of India, he automatically assumes the office of the chairman Rajya Sabha. He is not elected, but he is an ex officio chairman. So whenever I use the word ex officio, you can have a general understanding that the person who occupies a post ex officio, by virtue of his office somewhere else or by virtue of his position somewhere else, he automatically occupies this particular office as well. That is basically what is called as ex officio. In the future, I will come across this particular word number of times, not only in case of the vice president who is ex officio chairman of Rajya Sabha. In certain constitutional bodies, in certain statutory bodies also ex officio positions are there. But what does it mean by ex officio? By virtue of one's office or by virtue of one's position. That is basically what is called as ex officio. Is that clear? Alright. So what is the next keyword? Veto powers. What do you mean by veto powers? Not in the case of the Indian polity, just whatever you know about veto powers. Can anyone tell me? Yes? Very good. Absolute authority to reject a proposal. So that is basically what is called as veto. Say for example, you might have heard about the P5 members in the United Nations. The permanent 5 members, a speciality of P5 members in the United Nations is every permanent member has got veto powers. That means even if the other members agree with a particular decision, even an individual member among the P5 members can veto the decision. So that is basically what is the veto power. So similarly, under the Constitution of India, the president and the governors are given certain veto powers and they have the power to reject despite certain things are approved by the legislature, and that is basically what is called as veto powers. I am not going to discuss in detail as to what are the various veto powers that the president and the governor has got, which we will subsequently discuss when I take up the president. But in general, what do you mean by veto powers in the context of Indian polity? These are all powers exercised by the president and the governors. Does anyone know which article gives this power to the president and the governors? Of course, with regard to the power exercised by the governor, today recently the Supreme Court has given a judgment on this, how they can exercise this power, which I will subsequently discuss. But in general, these are all the powers exercised by the president and the governor to reject the bills that is presented to them. To reject the bills that is presented to them. Now try to understand who is supposed to make laws in our country. The parliament and the state legislature. They are the legislative body, they are supposed to make the laws. But despite the fact that the parliament has passed the bill and the state legislature have passed the bill will never become an act unless and until the assent is given by the president, unless and until the assent is given by the governors of that particular state. So assent means a formal approval which is given by the president, a formal approval which is given by the governors. Unless and until they give that, the bill will never become an act. And in fact, in the last class, if you remember, I said that the president is an integral part of the parliament. Do you remember? But I didn't tell the reason as to why he is considered to be an integral part of the parliament. Did I say the reason? But I told you to remember that he is an integral part of the parliament, but he is not a member of parliament. What is the primary function of the legislature? To make laws. But the legislature alone cannot make the laws. The legislature, the bill can be introduced, the bill can be passed even by the majority members, but that bill will never become an act unless and until who gives the assent to that particular bill? The president gives the assent to the bill. So, therefore, the president is also involved in the law making process, because unless until the president gives the assent, the bill never becomes an act. So, therefore, in the entire process of law making, who is also involved? The president is also involved, and for certain other reasons also, subsequently you'll understand, the president is also considered to be an integral part of the parliament. Similarly, when a bill is introduced in the state legislature, after the bill is passed by the state legislature, who has to give the assent to that particular bill? The governor has to give the assent to the bill. Unless and until the governor gives assent to the bill does not become an act. So, therefore, the governor is also an integral part of the state legislature. Is that clear? So, whenever the bill is presented, the president and the governor can exercise certain amount of veto powers. Now, what are those veto powers? I will discuss elaborately later, but right now try to understand what does it mean by veto power? The power to reject the bills despite it is passed by the legislature, despite it is passed by the parliament, despite it is passed by what is called as a state legislature. That is basically what is called as the veto powers. But can anyone tell me which article in the constitution gives this power to the president and the governors? There are a lot of ifs and buts with regard to how they can exercise this veto powers, which I will subsequently discuss. Is article given in the handout? Okay. So, the article is article 111 in case of the president. And what is article in case of the governors? It is article 200 in case of the governor. So, this is what is giving the power. It is not. Okay, it is given for the ordinance. Ordinance is a different article, article 123 and article 213. So, this is in case of the veto powers. So, is the concepts clear to all of you? Can anyone just give me the handout? Okay, so let me just take a moment. Let me just go through all the things and then I will proceed further. So, is it clear with regard to what is judicial review, what we discussed? So, judicial review should be strictly in accordance with what? It is strictly in accordance with the constitution. Is it clear as to what is an amendment? Amendment means changes to the constitution, and who is authority to amend the constitution? Only the parliament. The parliament can do it under article 368 and outside article 368 also, but in which case it is complex? When it is done under article 368. How many amendments happen under article 368? 106 amendments. And rights, we have seen. What is basically a right? It is a claim and an entitlement basically an individual has got. And what are the different types of rights that you have seen? Fundamental right, constitutional right and legal right, which is at the highest priority, fundamental right. In other cases, both in case of constitutional right and the legal rights, when they are violated, the affected individual cannot directly approach the Supreme Court. They can go only through the ordinary hierarchy of courts. Writs. What does it mean by writ? These are basically directives given by the courts to protect the rights or to provide remedy to the individuals. And what are the types of writs that they can be issued? 5 types of writs. And what article empowers the Supreme Court to issue this 5 type of writs? Article 32. Which article empowers the High Court to issue these writs? Article 226 of the Constitution. And then what does it mean by nominal executive? Namesake, a formal head. Who is a namesake or a formal head in the union? Who is a namesake or a formal head in the state? Governor. And what does it mean by an electoral college? Group of people who are eligible to vote in elections, but the electoral college can be different for different types of elections. And what is the advantage of the first past the post system? It is simple in terms of declaring the results. So, that is one of the major advantage. And what is the advantage of the proportional representation? It reflects the will of the people. So, depending upon the percentage of votes, the those many representatives can be there in the legislature. So, you also understood the secret ballot and open ballot, ex officio, veto powers. Okay, so come to the next thing, that is ordinance. Don't worry about it. I'll deal with that, because when I take up the legislative body, I'll deal with these things as to proportional representation. Even with regard to the election of the president and vice president, I'll deal with the proportional representation. At the time, I'll deal with all those things. Right now, just try to understand the formal thing. Okay. So, whenever I go to the respective areas, I'll deal with that in detail. Sometimes whatever is given in a handout may not be covered, because handout we cannot give a less note. So, those may be a little detailed, but I know when to cover and which would be more appropriate. Okay. So, in case if I am not teaching something, if it is there in the handout, there is nothing to panic. All those things will come at the later stages. So, come to the next thing. What is the next topic? Ordinance. Can anyone tell me what is an ordinance? No, what is an ordinance? Who is supposed to make laws in our country? It is a parliament and the state legislature. That is a legislative body supposed to make laws. But what if the legislative body is not in session? It might be a possibility that the legislature is not in session. That means the legislature has not come forward. They are not working presently. They are suspended presently. Is that a possibility? Can there be a possibility? So, for example, during COVID time, the parliament did not meet for almost 6 months, and everybody was afraid of COVID. So, nobody knew that what is the severity, and the parliamentarians are not exceptions. They are not, of course, going to make law just giving their life. That is not going to work that way. So, most of the parliamentarians, or the parliament was suspended, or in other words, the parliament was not in session, it was not functioning actively. Under such a scenario, when the parliamentarians are not meeting or they are not working, but there is an urgent need to bring a law. There is a need for a law, because a country cannot be governed without a law. If there is a need for a new law, the new law has to be made. But who is supposed to make the law? The parliament is supposed to make the law, but the parliament is not in session. So, under such a circumstances, there should be an alternative way of making the law. So, normally try to understand. So, this was there in the vision of the members of the Constituent Assembly, that generally who is supposed to make the law? The parliament in the union and the state legislature in the states. But they also had a vision, what if the parliament is not able to meet for some reason? What if the state legislature is not able to meet for some reason? It is not only because of COVID, it may not be only health crisis. It can be an emergency, it can be a war-like situation where the parliamentarians is not able to meet. But if there is a need for an urgent law, then what is the alternative route to make the law? It is through ordinance. So, ordinance is nothing but the law made by the executive. So, who is making the law here? The executive is making the law. But however, the difference is, this is a temporary law that is made by the executive. So, to say that it is just a law is not the right thing. It is a temporary law which is made by the executive. And who is the executive who is empowered to make this temporary law? The president at the union level and the governor at the state level. So, the governor and the president can issue what is called as ordinance. The president can issue the ordinance under Article 123 of the Constitution. And the governors can issue ordinance under Article 213 of the Constitution. So, this is basically what is called as an ordinance. So, what is ordinance? Ordinance is a temporary law made by the executive. This is basically the ordinance. So, the president can do it under Article 123 and the governor can do it under Article 213. Why do I call that to be a temporary law? But whereas a law made by the parliament or the law made by the state legislature is not said to be a temporary law. But here I am saying this to be a temporary law. What does it mean when I say it is a temporary law? Very good. It has to be approved by the legislature. Once the legislature comes to session, the legislature has to approve that. If the ordinance is issued by the president, then who is to approve this ordinance? The parliament is to approve the ordinance. If the governor is issuing an ordinance, who is to approve this ordinance? The state legislature has to approve this ordinance. There is a time limit under the constitution within which they have to approve. Anyways, I will discuss about all those things at the later stages, but right now try to understand Unless and until they approve these ordinances, then the ordinance will lapse, it will become invalid. So, ultimately who is authority to approve this? It is only the legislature. So, till the time it is approved, the ordinance can be in force. If they do not approve, then the ordinance will expire or the ordinance will become invalid. So, this is what is called as the ordinance making power. But as a general rule, try to keep this in your mind. The president has a power to issue ordinance on all the subject matters or all the areas on which the parliament can make laws. Wherever the parliament can make law, on all those areas, who can issue the ordinance? The president can issue the ordinance. And whatever subject matter, whatever areas on which the state legislature is empowered to make the law, on all the areas, who is empowered to issue the ordinance? The governor is empowered to issue the ordinance. But in all these cases, they are only temporary laws. Is it clear? This is a general understanding you should have. We are not going in detail into ordinance. My idea is, when I tomorrow say ordinance, you should be in a position to comprehend what is an ordinance. In one single line, can anyone tell me what is an ordinance? Ordinance is nothing but a temporary law made by the executives. That is the only thing that you should have an idea presently. What is the next keyword? Political defection. How many of you heard about this political defection? Most of you heard about this political defection. Okay. So, sometimes it is often referred as defection, not necessarily political defection. Even the word defection in the context of Indian polity means political defection. So, what does it mean by political defection or defection? What is your understanding of political defection or defection? Changing of one's party loyalty. That is basically what is called as defection. Okay, suppose let us assume a party worker is there. A party worker is there who is in party a member of a political party. Let us assume a member of a political party. He is a member of a political party A, and what he does is, this member, let us assume X, he joins party B. Does it mean that he is politically defected? Yes. He is a member of a political party, that is what I said. So, for example, there are political parties who have 10 crore workers. There are regional parties that are 2 crore party workers, or they have got association with that particular political party. They are a member of that particular political party. If they join another political party, will that amount to what is called as political defection? No, it does not amount to political defection. Then what amounts to political defection? So, you mean to say it does not apply to all the members of the political party, it applies only to a member of a legislature party. Okay, so I am using the word legislature party. I will subsequently explain as to what is a member of a political party and member of a legislature party. There is a difference, because most often this particular word is used in the newspaper. So, you should be in a position to understand a member of a political party and a member of a legislature party. Now, what does it mean by member of a political party? Anyone who is associated with the political party is a member of a political party. But who is a member of a legislature party? A member of a legislature party is someone who is not only a member of that particular political party, but was contested election from that particular political party and got elected as an MP or an MLA from that particular political party. Then he would be belonging to what is called as a legislature party. Or in other words, suppose let us assume there is another member Y who also belongs to this particular political party, but Y has contested election from the party ticket that is given by A. Party ticket that is given by A, and then Y has become an MP in the Lok Sabha. And from which party he has contested election? He has contested from party ticket that is given by A, and subsequent to he becoming a member of parliament, now he joins party B. Now he goes and joins party B. In these cases, which is considered to be political defection? Is it X or is it Y? Political defection is only what is called as Y. This is not political defection. Because he is just a member of a political party, but whereas Y is a member of a legislature party. That means he has got elected from the party ticket that was given by A, and then subsequently has got elected, and then now he joins what is called as political party B. Now, does it amount to mockery of the democratic process. Whatever Y has done, does it amount to mockery of the democratic process, or to put it in a very direct form, does it amount to cheating the people? How does he cheat the people? Because anyways he got elected and then he joins, he should be free to join any party as per his will. Because in our case, in case of India, most of the cases when they contest from a particular political party, people vote to that particular candidate because he is contesting election from a particular party, and because he is belonging to a particular party, the possibility is that he has won the election. Otherwise, if he is so famous, he would have contested as an independent candidate, but he has contested from a particular party, and because he contested from a particular party, people might have voted. And now if he is joining another party, then he is cheating all the voters who voted to him. So therefore, if somebody is engaging in political defection, there has to be some punishment. And what is the punishment that the constitution gives for someone who engages in what is called as political defection? He or she is liable to be what is called as disqualified. They can be disqualified to be a member of parliament or a member of state legislature, whatever it is. So they can be disqualified for what is called as political defection. How they are disqualified, who is authority, it's a very detailed thing that I'll discuss. But as of now, I just wanted to explain as to what is political defection. Is it clear to all of you what is political defection? Political defection means what? Somebody who is a member of a legislature party, he cannot join another party. He should continue to be in that particular party till the term is getting expired. So suppose let us assume Y got elected from the party ticket and he become an MP, but he served as an MP for 5 years, and then the Lok Sabha is dissolved. When the new election comes, can he join another party? Yes, then he can join another party, not an issue. But during the term as an MP, he should not join another party. In that particular case, he has defected from that particular political party. And what is the punishment in case of political defection? He or she is liable to be disqualified. But does anyone know which article in the constitution deals with this anti-defection? Or let me discuss that later. At least tell me that, is the political defection part of the original constitution? Was it there in the original constitution? No, it was not there. So there was some amendment based on which this was brought in. Okay, you are right. Which amendment? Which amendment? 50? Very good. 52nd Constitutional Amendment Act 1985. It was only in the 52nd Constitutional Amendment Act 1985 this was brought in. In 1985, they brought in this defection. That means 35 years after the commencement of the constitution. That means, do you think that for the first 35 years there was no defection? There was defection in fact, but the original constitution does not provide for the defection. What could be the reason? In fact, the defection was a serious issue during the late 1960s. In fact, there is a political narration. There was a scenario what is called as Ayaram Gayaram in the Legislative Assembly of Haryana. It is said that within single day he joined 3 parties. In the morning he was in one party, afternoon one party, evening one party, and he has brought down multiple governments. Although this is not the exact political narrative, but this is just to say what is the severity of political defections. And because any government to survive, they need to have the majority. And if the majority is not there, if somebody is getting elected and then he joins another party, then the governments can be brought down. Because in a parliamentary democracy, we have already seen what? That the government should always have a majority in the respective legislature. So therefore, this defection become a very serious issue. And in order to avoid this particular defection, they thought that how they can prevent a particular member from getting defected is that if they are doing that, then the punishment would be disqualification. And it was brought in by the 52nd Constitutional Amendment Act in 1985. Does anyone know who was the Prime Minister of India at that point of time? It was Mr. Rajiv Gandhi who was the Prime Minister when this came. But they took efforts right after late 1960s, but it culminated only in 1985. But however, for the first 20 years at least, after the commencement of the constitution, it was not so serious, and the Constituent Assembly even never thought about political defection. Now, why do you think that the Constituent Assembly, the original constitution, has not brought in any provisions related to defection? The country? Maybe the conscience of the members was so high that they are not engaging in what is called as defection. And another possible reason could be, at that point of time, there was only one dominant party. It was only Congress party, so nobody had any benefit of defecting from Congress to another party. So therefore, that was not a very big issue. But soon after the commencement of the constitution, there are a lot of regional parties, and then certain other dominant parties also started coming. Then the issue of defection started, and then subsequently the defection also become part of the constitution. And there is one schedule that is associated with the defection. Which schedule in the constitution? 10th schedule. Even this information has been asked many times in the examination. Which schedule in the constitution is related to what is called as defection? Just remember as of now 10th schedule. But defection is a very big topic. It will take me around 1 hour to complete the entire defection. If you have to understand the entire defection, but I will do that when I take up the Parliament chapter. Alright. But right now I just wanted you to understand what is defection. Yes, who has asked the question? Yes, yes. It is applicable both in case of members of Parliament as well as the members of the state legislature. When I say members of Parliament, it is applicable to members of the Parliament both in Lok Sabha as well as in Rajya Sabha. It is applicable to the state legislature. It is applicable both to the members of the Legislative Assembly as well as Legislative Council. Okay. I will discuss all those things at the later stages. First, we will have to understand what are the grounds for defection and all those things. Then we will take those examples. So, right now it is just I am trying to give the definition, the basic understanding. What is the next topic? Okay, bills. Write down the next topic, bills. Can anyone tell me what do you understand by the word bill or bills? Bill, let me take the word bill. In one single word, if you have to put it across, what is a bill? Bill is not a law, because bill has no legal sanctions. Bill cannot be implemented. Bill is merely what? It is merely a legislative proposal. It is merely a proposal. It has no legal sanctions. Do you think a bill can be implemented? The bill has no legal sanctions. Bill is merely a proposal which is introduced in the houses of the Parliament, or it is introduced in the houses of the state legislature. By any member of that particular legislature, a bill can be introduced in that particular house. That means there is an intent on the part of that particular member to bring this proposal as a law once it goes through all the process. But till the time it goes through all the process and then it receives assent from the president or the governor, it is merely a legislative proposal. Or you can say it is an initial point. Later it may or may not become what is called as a act. It may or it may not become what is called as a law. Alright, so this is basically a legislative proposal. So henceforth when I use the word bill, what is understanding you should have? It is merely a legislative proposal. And who can introduce this particular bill? The members of the Parliament or the members of the state legislature can respectively introduce in their respective legislature. But however, the bills can be classified into two types of bills. In fact, there are a number of types of bills, but right now I want to restrict the discussion to two types of bills. And depending upon who is introducing this bill. Who is introducing a bill, the bill can be classified into two types. And what are the classification? Depending upon who is introducing the bill can be classified into what is called as a private member bill, and then what is called as government bill. So these are the two ways it can be classified. It can be classified into what is called as a private member bill and what is called as a government bill. Now what does it mean by a government bill and what does it mean by a private member bill? So what does it mean by a government bill? A government bill is a bill which is introduced by a minister. We know that a minister is also a member of Parliament. A minister is also a member of state legislature. So if any bill is introduced by a minister himself, then such a bill is what is called as what? Government bill, which means this bill is having the backing of the government. But if a bill is introduced by a private member, so therefore it becomes a private member bill. So we'll have to understand as to who is a private member. So first of all, what is a government bill? A bill which is introduced by a minister, which is having the backing of the government, then it becomes a government bill. And what is a private member bill? If a bill is introduced by a private member, then it becomes a private member bill. But the question is, who is a private member? So private member is very simple. Anyone who is not a minister but a member of Parliament or a member of state legislature is a private member. So just try to remember this or write it somewhere. I do not know whether it is given in the handout, but yes, you can just make a note of it. Who is a private member? So write down one line on who is a private member. Anyone who is not a minister, anyone who is not a minister, anyone who is not a minister but a member of the legislature, anyone who is not a minister but a member of the legislature is a private member. Anyone who is not a minister but a member of the legislature is a private member. That means what is understanding you should have? Any member of parliament, let us take the example of the parliament, any member of parliament but who is not a minister, then he is a private member. That means, can a private member today, can he be from both the BJP party as well as from the Congress party? Is that possible? Is that possible or not possible? How many MPs are there in the BJP party? Let us assume, I do not know the exact count in the 18th Lok Sabha, but I think it is somewhere near 220. I remotely remember. I remember 240 maybe, okay, but they do not have the independent majority. I think around 240, okay. So let us assume 240. 240 MPs elected to the Lok Sabha from the BJP party, but how many ministers are there presently in our country is approximately between 70 to 80. So that means even in the BJP party, not every member of parliament is a minister. So now try to understand, this is one mistake normally the student do, that is why I am repeating it again. They usually think that a private member is a member of parliament usually from the opposition party. No, a private member may be from the ruling party or from the opposition party, but a member of parliament who is not a minister. So whoever is not a minister, whether he is from the ruling party or an opposition party, if they introduce a bill, then that is what is called as a private member bill. Is that clear to all of you? So what is a private member bill? A bill which is introduced by a member of parliament but not a minister. It does not matter whether he is from a ruling party or from an opposition party, then such a bill would be considered to be what is called as a private member bill. And what is a government bill? A bill which is introduced by a minister is what is called as a government bill. Is that clear? So this is basically depending upon who is introducing the bill, but depending upon the subject matter of the bill, that means what the bill deals with. The bill can be classified into number of types, but I will discuss that later. So right now I don't want to discuss that. Now what do you understand by subject matter of the bill? Subject matter of the bill means what they actually deal with. They may deal with taxation, they may deal with some punishments in case of offences. So depending upon what they deal with, the bill can be classified into different types. But depending upon merely, irrespective of the subject matter, merely who is introducing the bill, it can be classified into what? It can be classified into what is called as private member bill and government bill. Depending upon the subject matter of the bill, again there can be classifications. So you don't have to worry about it at this stage, but depending upon the subject matter, it can be classified into money bill, financial bill, ordinary bill, constitutional amendment bill. So lot of distinctions are there, which I'll discuss when I take up the parliament chapter. But right now try to understand just what is a bill, and depending upon who is introducing a bill, the bill can be classified into two types. What are the types? Government bill and private member bill. And I'm sure that you are having an understanding of as to who is a private member. Is it clear to all of you? All right. So come to the next keyword. What is the next keyword? Assent. Assent, I think in the course of the discussion I already discussed. Assent means a formal approval. Assent means formal approval. In the context of the polity, we normally use this word assent in the context of the president and the governors, especially after the bill is passed by the parliament and the state legislature. Once a bill is introduced in the parliament and the state legislature, there is a legislative proposal, which is a bill which is introduced in the parliament and the state legislature. It goes through a number of steps. We already seen that it goes through a number of steps, and after it goes through all these steps, and then finally it goes to the assent of the president and the governor, where the president and the governor has to give the formal approval. Only after they give the formal approval to the bill becomes an act. Till that point of time, it is only considered to be a bill. Say for example, we have recently heard about the Waqf Amendment Act, but this became an act only after it was given approval by the president. Initially when it was discussed in the parliament, it was only called as a bill. So, till the time the assent is given, it is only a bill, and as long as it is a bill, it cannot be enforced in a court of law. It has no legal sanctions. The moment it is given approval by the president, the bill becomes an act, and the moment the bill becomes an act, it can be implemented by the executives, and people are not following the law, then they can be punished, but only after the bill becomes an act. And when the bill will become an act? Only after the assent is, formal approval is given by the president, and similarly only after the formal approval is given by the governor. That is basically what is called as assent. Now, before the assent is given, the president can also exercise what is called as veto powers. That is what he can sometimes reject it also, but under what circumstances he can exercise his veto powers, we will discuss that later. Okay. So, mostly in all the cases they will give the assent, but in the entire constitutional history of 75 years, we have one or two instances where the president have exercised his veto powers, but we will discuss about that at the later stages. What is the next keyword? Collegium. How many of you heard about this word collegium? So, collegium in general means, again, it is a group of people. So, that is basically what is called as collegium, a group of people who get to decide certain things. That is basically what is called as collegium. But in the context of our political system, in the context of the Indian constitution, collegium generally refers to a group of judges of the Supreme Court. That is basically what is called as collegium. So, presently, do you know what constitutes collegium in the Supreme Court? Very good. It is Chief Justice of India plus 4 senior most judges is generally that constitutes what is called as collegium, and it is the collegium today decides as to who shall be appointed as the judges of the Supreme Court and also the judges of the High Courts. That means who appoints the judges of the Supreme Court and High Court? Not the collegium, the President of India. But however, who shall recommend the names to the President of India as to who shall be appointed as the judges of the Supreme Court and High Court? It is a collegium that makes the recommendation. So, collegium in the Indian context is broadly referring to the group of senior judges in the Supreme Court, which also includes the Chief Justice of India. Presently, the collegium consists of Chief Justice of India plus 4 senior most judges who are next to him, and it is a collegium that will make the recommendation to the President of India as to who shall be appointed as the judges of the Supreme Court as well as the High Courts, right. So, only as per the recommendation of the collegium, the President can appoint the judges of the Supreme Court as well as the High Court, although there is a little bit of change in the collegium when it comes to the High Courts, which I will subsequently discuss, but primarily it is done by what is called as the collegium. Now, is the word collegium mentioned in the Constitution? Does it find mention in the Constitution? How many of you think it has no mention in the Constitution? The collegium is nowhere mentioned in the Constitution. Then how did this collegium came into existence? It is only through judicial interpretation of the Constitution. That is why I said even the judicial interpretation would amount to what is called as a constitutional law. Although it may not be directly mentioned in the Constitution, but still what becomes part of the constitutional law? The interpretation that is given by the Supreme Court, because there is a saying, the Constitution of India is what the Supreme Court says it is, because ultimately who is the final interpreter of the Constitution? It is the Supreme Court. So, therefore, their decisions, their interpretations is also part of what is called as a constitutional law. Is it clear to all of you what is collegium? There are a lot of things that we have to discuss about the collegium, but I will discuss all those things when I take up the judiciary, but right now you should have the idea of what is this collegium. You should be in a position to understand these keywords. What is the next keyword? Suo motu. Have you ever heard of this word suo motu? Can anyone tell me what does a suo motu means? So, it can be interchangeably used. Sometimes it is called as suo motu, or it is also used as what is called as suo motu. In both the cases, it is having the same meaning. What does it mean? Suo motu or suo motu? On its own. It is, to put it in a simple way, on its own. When they initiate any action on their own, then it is what is called as suo motu. So, normally where we use this in case of the courts, we use this in case of certain quasi judicial bodies, we use this in the case of certain constitutional bodies that they can take up cases suo motu. That means on its own. So, do you think that the Supreme Court of India can take up cases on their own? Yes, nothing prevents the Supreme Court of India from taking cases on its own. In extreme circumstances, they can take up cases on their own. Okay, so based on the newspaper reports and all those things, if they find certain things are very grave in the country, they can take up cases on their own. That means basically they are taking cases what is called as suo motu or suo motu. That is basically what is called as on their own. What is the next keyword? PAL. PIL means public interest litigation. How many of you heard about this particular word? PIL, public interest litigation. So this PIL is also closely associated with another keyword that you have to discuss. So therefore, you can write that also. I think that should be the next keyword also. Okay, so there is something which is called as locus standi. So you can remember this also. Locus standi. In fact, this is a Latin word. First, I will discuss the word locus standi. Then I will go to what is called as PIL. How many of you heard about this word locus standi? Or locus standi, whatever it is. This is a Latin word which means what is your standing. So it literally means in Latin what is your standing, which means to elaborate this further, locus standi means we know that wherever there is a right there is a remedy. So means which means whenever there is a right is violated there is a remedy. So therefore, if our rights are violated, what we can do? We can go to the courts, and when we go to the courts, the first thing that the judges will try to assess is what is your standing in this particular case. That means, is your right anyway affected? Because if our right is affected, then we do have a standing. Is that right? Then we have a standing because we are affected in this particular case. So the first thing that the judges will try to assess whenever the individual go to the court is that the court will try to assess that what is the standing of that particular individual, or in other words, the court will try to assess the petitioner who is filing the case, does he have an interest, does he have a standing. That is basically what is called as locus standi. That means in short form, if the court is saying what is your locus standi, that means what is your standing or what is your interest in this particular case, are you affected because of this particular case. If you have the locus standi or if you have the standing, then you also have the right to approach the court. That is basically what is called as locus standi. This is the traditional principle that was followed by the judiciary. So traditionally, what was seen by the judiciary? If somebody goes and knocks the doors of the judiciary, what is the first thing that the judiciary is trying to verify? Whether the individual is having a standing in this case, whether the individual has got a locus standi. If the individual has got the locus standi, then the judiciary will accept that particular case. Otherwise, the judiciary is not going to accept this particular case. But what is the drawback of this particular principle, locus standi? Is there any drawback? So, for example, somebody who is not having the resources, multiple reasons could be there. Somebody who is not having the legal knowledge, somebody is illiterate, somebody is not having the resources despite all those things. So, is it possible that they may not be able to go to the courts? And because they will not be able to go to the courts, then their rights will get violated. So, this was brought to the notice of the judiciary, and over a period of time, the judiciary has also accepted this particular thing, that if you are strictly looking for the standing of a particular individual, whenever a case is filed, it might be possible that there can be lakhs of people who may not be able to approach the courts because they may not have the knowledge, they may not have the resources. So therefore, over a period of time, the Supreme Court liberalized the principle of locus standi. The Supreme Court said that not in all the cases we will look for what is called as a locus standi. But even without a locus standi, we can still accept the petition. And such type of petition where there is no locus standi which is accepted by the court is what is called as public interest litigation. So what is public interest litigation? To put it in a very simple way, these are all litigation which is filed by an individual not for his own interest, but for the interest of the others in the society, but for the interest of the general public. That is basically what is called as locus standi. Sorry, that is basically what is called as public interest litigation. Say for example, let us assume that I am not directly arrested by the police, I am not affected, but I know that there are few illiterate people who are arbitrarily detained by the police and they are harassed by the police in my locality, let us assume. But I am not arrested, I have no locus standi in this particular case. But as a public spirited individual, I feel that the atrocities are very high. So therefore, can I file a petition in front of the court on behalf of those individuals? If I file, do you think that I have a standing in this particular case? I have no locus standi. but it does not mean that the court will not accept this petition. The court will still accept this petition, but they will accept this petition as what is called as public interest litigation. So, what do you understand by public interest litigation? These are petitions filed in front of the court where there is no locus standi, or where the principle of locus standi is liberalized. That is basically what is called as public interest litigation. Now, initially this public interest litigation was not allowed in the Indian courts, because the courts were strictly looking into the concept of what? Looking into the concept of locus standi. But starting 1970s, the courts have gradually liberalized and they have started allowing what is called as a public interest litigation, and today the public interest litigation is very popular in our country. So, whenever I use the word public interest litigation, immediately what should come to your mind? That the court does not look into what is called as locus standi wherever there is public interest litigation, because public interest litigation, as the name suggests, these are not litigation for one's own interest, but for the interest of the general public. So, there is no locus standi in this particular case. Is it clear to all of you? But the entire public interest litigation concept is so important. We will discuss advantage, disadvantage, case laws and all those things, but I will do an elaborate thing when I take up what is called as a judiciary. But right now the understanding, the idea is just to make you understand as to what is public interest litigation. Yes, as long as it is, so the court has put some restrictions with regard to where they will allow this public interest litigation. Public interest litigation is majorly entertained by the court in case of violation of fundamental rights, not in case of the other rights. So, when the fundamental rights are violated, the courts normally do not look into what is called as locus standi. It can entertain this PIL and they can look into this particular matter, because the fundamental rights are seen as so important, not for the other ordinary legal rights or constitutional rights. Alright, shall I move forward? Is it clear to all of you till this point of time? Can I have a better response? Little louder? Okay, so what is the next topic? Tribunals. We are left with how many topics? 3 more topics. Okay. But the class is not over after the 3 topics. The class will continue, but this topic might get over. Okay, write down the next thing, that is tribunals. Okay, so have you ever heard of this word tribunals? Can you give me examples of some tribunals that you might know today? National Green Tribunal, any other tribunal? Tribal Claims Tribunal, okay. So Green Tribunal, that is National Green Tribunal, okay. Okay, Foreigners Tribunal, very good. So Foreigners Tribunal is a tribunal that is established to identify the bona fide citizens, and the illegal migrants can be deported after the cases are tried in the foreign tribunals. Okay, very good. Any other tribunal? Okay, so there can be specific tribunals in different cases. How many of you heard about the Central Administrative Tribunal, Taxation Tribunals, Electricity Tribunals, Railway Tribunals? A lot of tribunals are there in our country. So what basically is this tribunals, and what role or what purpose do they serve when we already have courts? Because we do have system of we do have hierarchy of courts. We have the Supreme Court, we have high courts in each and every state, in almost all the states, and below the high courts we have subordinate courts, including the district courts and other courts. And despite all those things, what is the relevance of these tribunals? Are the tribunals and the courts one and the same, or are they different? Different? Okay, 2 questions I wanted to put, you can think about it and answer. Now, first question is, to what extent do you think the tribunals and the courts are different, and what purpose do you think that the tribunals serve in our country today? First, to what extent are they different, the tribunals and courts? Okay, so the courts are judicial in character and the tribunals are quasi judicial in character. That could be one of the major difference. But what do you understand by quasi judicial? That is again the same meaning. Can you further elaborate when you say quasi judicial or semi judicial? Yes, they have a limited purpose. Okay, that is again a difference, but I was trying to understand the quasi judicial. So when you say quasi judicial, can you further elaborate? No, even the judiciary has got administrative functions. Say for example, the judges will also go for leave. If the judges also make some mistakes, then the Chief Justice has to take some actions, disciplinary actions. So the judiciary will also have administrative functions. In fact, the Chief Justice of India is the administrative head of the Supreme Court. Similarly, the Chief Justice of every High Court is the administrative head also. They will also have administrative functions in their respective domain. But why do you think that the tribunals are called as quasi-judicial? They are considered to be quasi-judicial for a number of reasons. Yes.
They are more of a dispute research body rather than.
No, in case of judiciary also, they were, even the judiciary was, before the tribunals were created, the judiciary were addressing all these issues. It is only the judiciary where we'll have to go. Only after the constitution came into force, only after a few years these quasi-judicial bodies came into existence. Okay, one is, yes, their jurisdiction is very narrow than that of what is called as judiciary. While in judiciary, there is no restriction as to what kind of cases can be entertained. But when it comes to a tribunal, there is a very narrow jurisdiction for every tribunal. So, for example, what is the jurisdiction or what type of cases can be entertained by the National Green Tribunal? Only environmental disputes, no other disputes apart from environmental disputes. What type of disputes can be entertained by the Administrative Tribunal? Only the dispute between the government employees and the government. Only such disputes can be entertained. So you might ask me, what could be the dispute between a government employee and the government? Of course, there's a lot of dispute that can happen. Can you just think of some dispute between a government employee and the government? Promotions, transfers, punishments. So everything can be challenged in the tribunals. And then taxation tribunal, only tax related disputes, nothing more than that. Electricity tribunals, the consumers who have got problem with the electricity consumption and all those things, only those matters. So therefore, the jurisdiction is very less, very narrow, and it is not as wide as that of the judiciary, but they are almost similar to that of the judiciary in terms of their functions. What is their function? Their function is also adjudication, to resolve the dispute. And to resolve the dispute also, we go to the courts also, but there the jurisdiction is much wider, but here the jurisdiction is very narrow. And again, why it is called as quasi-judicial body, apart from the jurisdiction, why it is also called as quasi-judicial body? Because the procedure that is followed in the tribunals might be little different from the procedure that is followed in the courts. And between the tribunal and the courts, where do you think that the procedure is very complex? It is in the courts, the procedure is very complex. That is why it is very time consuming. But whereas in the tribunals, the procedures are very flexible. The only thing that they have to ensure is that they have to follow the principle of natural justice. Otherwise, there is no rigid procedure. The tribunal themselves can maintain the procedure, but they should not be violative of the principle of natural justice. So the procedure is not very complex, but whereas in judiciary, the procedures are very rigid. So to that extent also, they are considered to be what is called as quasi-judicial in nature. Because of the narrow jurisdiction and because of the procedure being very flexible, they are quasi-judicial, but they are considered to be still quasi-judicial. The word judicial because the functions are almost similar, because they also resolve the dispute, here also resolve the dispute. But how they resolve the dispute, what type of dispute is a little different. So that is the reason they are considered to be quasi-judicial in nature. Okay, I use the word natural justice. What does it mean by the principle of natural justice? While I said that the procedure is very flexible in a tribunal, but without violating the principle of what is called as natural justice. What do you understand by the principle of natural justice? Very good. One of the principle, one of the aspect, one of the pillar of principle of natural justice, one should not be a judge of his own case. Okay, that is very unlikely to happen. Okay, then there is another very important pillar to say that yes, the principle of natural justice is followed. Yeah, repeat it. Very good. Both the parties should be given a reasonable opportunity. Without hearing the argument of both the parties, if the judgment is passed, then there is no principle of natural justice. Both the parties should be given a reasonable opportunity to explain their case. If the other party is not at all appearing after all the opportunity has been given, then it is not amounting to violation of natural justice. But a reasonable opportunity should be given to the other party also. That is, both the parties should put across their case, and after hearing both the parties, then the judge can pass the orders. So then we can say that the principle of natural justice is followed. If these principles are not followed, then that is not a right thing. So, all that the tribunal has to make sure is that they follow the principle of natural justice, but how they do it, it is up to them. So, they can have their own procedure, but the courts cannot have their own procedure. For the courts, the procedure is laid down in the various laws. So, for example, if it is a criminal dispute, the procedure is laid down in the criminal procedure code. If it is a civil dispute, the procedure is laid down in the civil procedure code, and what is acceptable as an evidence is mentioned in the Indian Evidence Act. But these laws does not restrict the tribunals. All the tribunals have to ensure is that they have to follow the principle of natural justice. Therefore, what is a natural advantage of a tribunal? It is a speedy trial will happen. So, they can conclude the cases at a much faster rate. And one other advantages of the tribunal also, unlike the judiciary, where the judges are only legal experts, in the tribunals there can be specialists also. So, in the tribunals, if you see, there will be multiple judges, minimum 2 judges when they hear the cases. One will have a judicial background, one will have a technical background. So, therefore, they can better understand the case and deliver the judgment. So, therefore, they have their own advantages also, these tribunals. So, this is what is the basic idea I should have about the tribunal. So, therefore, how you can describe a tribunal? A tribunal is a quasi-judicial body which is almost similar to that of the judiciary in terms of its functions, but however, they differ in certain other aspects, especially in terms of their jurisdiction, in terms of the procedure. So, they differ from that of the judiciary. So, this is basically what is called as the tribunals. Yes, temporary tribunals can also be established, but most of the tribunals are permanent, but we do have temporary tribunals. Say for example, the interstate river water tribunals, they are ad hoc tribunals, they are temporary tribunals, but not all the tribunals. So, to answer your question, can they be temporary? Yes, they can be temporary. Okay, so please, what is the next keyword? Constitutional bodies. Okay, what do you understand by a constitutional body? These are all bodies mentioned in the constitution. They are all bodies established by the constitution. I have categorically said in the last class itself that the moment you say that they are mentioned in the constitution, the word political party is mentioned in the constitution. Does it mean that the political parties are constitutional bodies? Not just because they are mentioned in the constitution, they do not become constitutional bodies. But a specific rule is directly establishing these bodies, then it becomes what is called as a constitutional body, and not just because it is mentioned in the constitution. So, to that extent, what about tribunals in our country? Are they constitutional bodies? The word tribunal is mentioned in the constitution. Does it make tribunal constitutional bodies? The tribunals are not constitutional bodies. What type of body is that then? Independent? Independent body is only to say that they are independent of the other organs, but that does not make it automatically the constitutional body. So, what type of body is tribunals? They are all statutory bodies. Anyways, I will discuss that at a later stage. So, now try to understand what is a constitutional body. These are all bodies established directly by the Constitution of India. A specific rule is dealing with these bodies and they are establishing these bodies. Can you give me some examples of constitutional bodies that we already discussed yesterday? Say for example, Article 148 of the Constitution, which establishes the Comptroller and Auditor General. CAG is a constitutional body. And then we also discussed about Article 280 of the Constitution, which establishes what? The Finance Commission of India is a constitutional body. Article 280 directly establishes the Finance Commission. Article 324 of the Constitution directly establishes the Election Commission of India, which is a constitutional body. Article 315 of the Constitution establishes both the Union Public Service Commission and the State Public Service Commission for every state. That is again a constitutional body. And then Article 338 of the Constitution, which establishes National Commission for Scheduled Caste. Article 338A establishes National Commission for Scheduled Tribes. Article 338B establishes National Commission for National Commission for Backward Classes. This is again a constitutional body. To name a few, these are all some of the important constitutional bodies. All these bodies are established by the respective articles in the constitution. So, therefore, these are all what is called as constitutional bodies. Now, do not have any misunderstanding that they are mentioned in the constitution, they derive the powers from the constitution, they are all only secondary things. But what is the primary thing to say that they are constitutional bodies? They are directly established by the constitution of India. They may derive the powers, they may not derive the powers. So, for example, the Election Commission of India does derive the powers, they are established by the constitution, they do derive the powers, but constitution is not the only source of power. They also derive the powers from the Representation of People Act, which is an ordinary law. So, therefore, deriving the powers from the constitution does not make it a constitutional body. What makes it a constitutional body? That they are directly established by specific provision in the constitution. Then it becomes what is called as a constitutional body. Is that clear? So, now the next thing I think is statutory bodies. Is it done? Okay, write down one more thing, statutory bodies as a continuation of that. As the name suggests, what is a statutory body? These are all bodies established by way of a statute. These are all bodies established by way of a law, an ordinary law, which is either passed by the parliament or the state legislature. Then it becomes what is called as a statutory body. Can you give me some examples of statutory bodies? I think I discussed few examples in the last class. Can you recollect some of the examples? The Reserve Bank of India, established by the Reserve Bank of India Act. Securities Exchange Board of India, established by the Securities Exchange Board of India Act. Apart from this, can you recollect some other examples? Yes. Can you expand it? Rural electrification. So Real Estate Regulatory Authority, yes, it is established by way of a act passed by the parliament. NABARD, yes, there is a NABARD Act which establishes the agricultural banks, national agricultural banks. SEBI, State Bank of India, yes, it does have a specific act. But let us look into a larger regulator. Anything which is established by way of a ordinary law, they are all statutory bodies. Anything, they are all statutory bodies. But again, try to understand, the questions are not very unlikely to come from a PSU, even though they are established. That is why we will have to see which has a national implication. Say for example, National Commission for Women. The National Commission for Women is a statutory body which looks into the protection of human rights throughout the country, very important. National Human Rights Commission, established by the Human Rights Act, that is a statutory body, it has a very important role to play. And certain other things which is coming in the newspaper should be picked up if it is coming in the newspaper and it has got a larger national importance or relevance. So, we should pick, because as I already suggest, as per the definition, anything which is established by an ordinary law, that is a statutory body, and we can come up with 1000 such statutory bodies in a country like India, but you cannot prepare all the 1000 statutory bodies and it is not relevant also. So, only there are 5 to 6 relevant things like National Human Rights Commission, then you have National Commission for Women, National Commission for Minorities, Lokpal Act, the Lokpal which is established by way of the Lokpal Act. So, these are all some important things. Okay. So, we will discuss about those things when I take up the statutory bodies, but right now try to have an understanding as to what is a statutory body. Okay, I just want to ask this particular question. What about CBI in our country? What kind of status does it have? Is it a constitutional body, statutory body, or body established by an executive order? There are also certain bodies which are called as extra constitutional bodies. Have you ever heard of this word, extra constitutional bodies? So, in general, extra constitutional bodies means, normally this is a term that is used to denote certain bodies which is neither established by the constitution nor by an ordinary law. So, such bodies are called as what? Extra constitutional bodies. Okay, that is what is an extra constitutional body. Now, come to the question that I asked, CBI. CBI, is it a statutory body, a constitutional body, or extra constitutional body? How many of you think it's a statutory body? Anybody who thinks it's a constitutional body? Anybody who thinks it's an extra constitutional body? Extra constitutional? Why? Why? Most of them are saying it is a statutory body. Delhi Special Police Establishment Act. Is that the act? Okay, so if your understanding is if it is established by the Delhi Special Police Establishment Act, then you should say it is a statutory body. But you raise your hand for the extra constitutional body. So because when you say it is based on that particular act, then the answer is a statutory body. I think that is the reason why you say that it is a statutory body. So I am just giving one more option, one more attempt for you to think about it. There are 4 options in case of CBI: constitutional body, statutory body, extra constitutional body. I do not know. So you can pick among any one of the options. Any answer from the online students?
Establishment of these bodies, so it can be due to an executive order.
Okay, just give me the answer, no explanation. What is the answer? Extra constitutional body. Now try to understand, the CBI today in our country is an extra constitutional body. Now the confusion that you might have is you all think that the CBI is established by the Delhi Special Police Establishment Act. No, CBI is not established by the Delhi Special Police Establishment Act. CBI is established by an executive order, but CBI as a body derives its power from the Delhi Special Police Establishment Act. That means, let us try to understand it like this. Suppose let us assume that tomorrow if some minister is creating a body, suppose let us assume the cabinet is passing a resolution, they are creating a body. That means they are creating a body by an executive order. But once a body is created, they derive the power from the Delhi Special Police Establishment Act. So if a body is deriving the power from a particular act, that does not make it as a statutory body. You will have to see how that body is created in the first place. So tomorrow if the CBI is to be abolished, just the ministers can pass an order and they can abolish it. But suppose if the body is a statutory body, the body can be abolished only by making changes in that particular law by the parliament. The ministers cannot do that. So therefore, if a body is created by an executive order, which means when I say executive order, who are the executives? The Prime Minister and the Council of Ministers. In fact, the CBI, when it was created by an executive order or an order passed by the Home Ministry in 1960s. But presently it is under the Ministry of, which is under the control of which ministry? Ministry of Personnel and Training. But when it was created, it was under the Home Ministry. So it was created by an executive order, but continued to derive its power from the Delhi Special Police Establishment Act. While the powers can be varied by making an amendment to the Delhi Special Police Establishment Act, but the body can be abolished by an executive order. So therefore, what is the status of the CBI in our country? It is only an extra constitutional body or a body established by an executive order. So can you give an example of any other extra constitutional bodies that you might know? Now, Enforcement Directorate has got a statutory status, which is recognized under the Prevention of Money Laundering Act, FEMA Act. It does recognizes Enforcement Directorate. Niti Aayog, very good. Niti Aayog is an example of what is called as extra constitutional body, which was established after abolishing the Planning Commission of India. So Niti Aayog is an example of extra constitutional body. CBI is an extra constitutional body. Law Commission of India is an extra constitutional body. So these are all established by an executive order. So whatever is established by an executive order, they are all extra constitutional bodies. Whatever is established by an ordinary law, that is all statutory bodies. Whatever is established directly by the constitution, that is a constitutional bodies. In fact, from this particular area alone, you will get 1 to 2 questions in your mains examination. If sometimes UPSC is giving more importance, they might ask 2 questions, but definitely 1 question is likely to come, mostly from the constitution or the statutory bodies. But anyways, right now we are not going in depth into that. Right now, you just have an understanding of what does it mean by these bodies. No, mostly the constitutional bodies are independent. Not necessarily only the constitutional bodies or independent bodies, but one of the salient features of the Indian constitution is that we do have a lot of independent bodies, which is provided by the constitution. So tomorrow let us assume a law is made, and that law also protects the functioning of that particular body from other two organs of the state, then also that body can also be an independent body. So it doesn't mean that independent bodies means only constitutional bodies. Independent bodies only means it is independent from the influence of other two organs of the state, which can be established by a statute also, by an ordinary law also. But under the constitution, we definitely have a lot of independent bodies. Some example include the Election Commission, the Comptroller and Auditor General, the Union Public Service Commission. They are all both constitutional as well as independent bodies. Okay. So with that, almost we are coming to the end of the keywords. These are all the keywords that I will be mostly using it again and again. So therefore, at that point of time, you should be in a position to comprehend. So that's the reason I am giving the keywords in the very beginning itself. So therefore, what are the things that you have covered till this point of time? We have covered, the first thing is we have tried to understand, what is a constitution. Then we also understood what is constitutionalism. We understood the definition of state, the political science definition of state. Then we have understood some of the salient features of the Indian constitution, and then of course we have understood what is called as the key terms that might be repeatedly used in the examination. So even from whatever I discussed in your prelims examination, you can expect 1 or 2 questions. Sometimes if luck is in your favor, even 2 to 3 questions can also come from these areas, just from the understanding of these basic concepts, because constitutionalism every year they are asking. The concepts like parliamentary democracy, most of the years they are asking. And apart from that, from the key terms also, like judicial review is one area where a lot of questions have come. So from these areas itself 2 to 3 questions can be answered. Please do not forget the concepts, and that will be only possible when you repeatedly revise the things. Now what happens with the students is you revise on a daily basis, then you don't touch it. And do you know how to, what is the strategy that you are revising? When you are coming for the class tomorrow, you should revise all the 3 classes. It is not that you will only revise only today's class. Only when you revise it like that, it will be in your long term memory. Now when you revise it for the second time or the third time, it is not going to take you much time. So for example, when you go to the home today, when you revise class number 3 today, it might take, how much time does it take for you to normally revise? It might vary from individual to individual, but 1.5 hours. For someone it can be 1.5, for someone it can be 2 hours, someone it can be 3 hours. There is no comparison in this regard. But for you, if it has taken 1.5 hours, if you are going to revise it tomorrow again, class number 3, today if you are revising class number 3, it has taken you 1.5 hours, tomorrow it will take only 45 minutes when you again revise the same thing. And if you are revising it for the third time, it will take you only 15 minutes. When you are revising it for the fourth time, it will just take 5 minutes. When you revise it for the fifth time, maybe 1 or 2 minutes, you will just skip and you will just look wherever you are having a problem. So if you revise it like that again and again, it is going to be much easier. But if you revise it only once and then you do not even touch it for next 1 month, then it will, like, all the things are gone. Then you will not remember. Probably you might remember 1 or 2 things here and there, but not everything. Okay. So to be successful in this examination, regular revision is very, very important. So try to revise it in this manner. All right. So now we'll move to the next topic. So please write the next topic, that is majorities. Also I have 2 minutes. Just go through your notes, and if you have any questions, both online as well as offline students, if you have any questions, you can ask me the questions, and then I'll move forward to the next topic, that is majorities. No. So I think that's a mistake. So if it is mentioned there, please make a small correction. NHRC is a statutory body. It is established by the Human Rights Act. Human Rights Act, I think 1993. So it is a statutory body, not a constitutional body. Okay, so how right to property is a constitutional right? I think that is not a issue to most of you, because the right to property is guaranteed directly under the constitution. And which article is protecting the right to property? Article 300A. So just listen to this article 300A. So what is article 300A of the constitution is saying? Article 300 is saying no one shall be deprived. So, this is the expression in Article 300, no one shall be deprived of their right to property except by an authority of law. So, this is what is mentioned in Article 300A. So, because it is guaranteed in the constitution itself, we are directly considering that to be what is called as a constitutional right. So, is it clear till this point of time? So, now your question is how it can also be considered to be a legal right. So, let us now go to that. Now, just read this particular statement. What is saying? No person shall be deprived, or no one shall be deprived of the right to property except by an authority of law. That means it is making it very clear, right to property is not an absolute right. Although right to property is guaranteed in the constitution, it can be taken away. But if at all the right to property, the property of a private individual, you, me here are private individuals and we do own certain property. So, if at all our right to property is taken away, what the constitution is saying, how it shall be taken away? It shall be taken away in accordance with the law. That means it shall be taken away by the state, and how it shall be taken away? And how it shall be taken away should be mentioned in a specific law that is passed by the parliament or by the state legislature. So, to that extent, the legislature has to make a law, and that law has to provide for the procedure as to how it shall be taken away. That is what is the meaning. So, that means it is saying that the right to property is not an absolute right, but if at all the property is to be taken away, how it can be taken away? It shall be taken away in accordance with law. So, that means first the legislature should make a law. So, under Article 300A, the legislature has the power to make a law, and in that law they have to provide for the procedure. So, they can give a detailed procedure as to how it can be done away. Say for example, one procedure should be the individual should be informed that the state wanted to take the property. So, first inform the individual should be given an opportunity to represent whether he wants to give the property or not to give the property. And then if the state decides to take the property, then the individual should be given a fair compensation. So, without compensation it cannot be taken away. So, all these things will be laid down in the law. And whenever the property is taken away from the private individuals, whatever is given in the law should be followed by the state. So, therefore, although it is guaranteed in the constitution, how this right to property is actually protected by a way of a law, because the law provides for the procedure, and because the law provides for the procedure, and therefore the law also protects the right to property, and therefore it can also be considered to be what? It can also be considered to be what is called as a legal right. So, it should strictly follow, the state should strictly follow the procedure that is laid down in the law. They should not acquire the private property in violation of the law. So, even by the law they can take it, but they have to follow the procedure that is laid down in the law. So, that is the reason it can also be considered to be what is called as the legal right. Is it clear to all of you? So, this is why it is both the constitutional as well as a legal right. Okay, so come to the next topic, that is majorities. This is again a very important topic, majorities. Now, why do you think that the majorities is very important, especially in a parliamentary democracy? Okay, what is collegium? So, one student is asking me the doubt on collegium. What is collegium? Collegium, I don't think it is a very difficult thing to understand. Collegium generally means group of people who decide on certain things. But in the context of our political system, the Indian polity, collegium basically means group of judges, group of senior judges in the Supreme Court. And what is their role? Their function is to majorly recommend the names of the judges who are to be appointed to the Supreme Court and the High Courts. And who appoints the judges to the Supreme Court and High Court? It is a president, but on the recommendation of the collegium. So, that is basically what is called as a collegium. But the word collegium is nowhere mentioned in the constitution. It is only through the interpretation of the constitution by the Supreme Court, the collegium came into existence. In fact, there are series of cases through which the collegium came into existence, which I will discuss when I take up the judiciary. But right now, just try to understand as to what this collegium is. Okay, come to the next word, that is majority. Now, why do you think that the majority or the concept of understanding the majority is very important in a parliamentary democracy? Now, why do you think it is very important? Because most of the decisions are taken by the parliament as to how the country is to be governed. So, for example, the law is made where? In the parliament, and most of the decisions are decided in the parliament, and most of the things which is decided in the parliament has to be done with certain majorities. And what majority that has to be, or what is the majority with which the things has to be decided, is given in the constitution itself. So, most of the things or most of the decisions that is taken in the parliament in a parliamentary democracy has to be approved by certain number of members in the parliament, and it is not a specific majority, or it is not one type of majority. There are different types of majority for different purpose. But today the idea is not to understand where what majority is used, but in general there are 4 types of majorities under the constitution, and these 4 types of majorities are used for different purpose. But our idea here is not to understand where these majorities are used, but just to understand what these majorities are. So, overall in the constitution, what are the majorities? There are 4 types of majorities. So, you can make a note of those 4 types of majorities if it is not there. The 4 types of majority, the first type of majority that is to be used is what is called as simple majority. And then the second type of majority is what is called as absolute majority. And then the third type of majority is what is called as effective majority. So, apart from the simple majority, absolute majority and the effective majority, there is also one more type of majority which is called as special majority. That means if the constitution is saying that simple majority is to be used for a particular purpose, simple majority should be there in the parliament. If the constitution is saying it requires absolute majority, then it requires absolute majority. If the constitution is saying it requires effective majority, it has to be satisfied with effective majority. But apart from these 3 types of majority, that is simple majority, absolute majority and effective majority, there is also one more type of majority which is called as special majority. So, overall in the constitution, there are only 4 types of majorities. It has to be either simple majority or effective majority or absolute majority or special majority. But however, one thing that you have to note before we proceed further, there is only one type of simple majority. There is only one way of calculating as to what is a simple majority. There is only one way of calculating what is absolute majority. There is only one way of calculating what is called as an effective majority, but there are multiple ways of calculating special majority, or in other words, there are different types of special majority. And what type of special majority for what purpose is also mentioned in the constitution. But overall, although there are different types of special majority, they are collectively called as what is called as special majority. Any majority apart from what? Apart from simple majority, absolute majority or effective majority, they are all called as what is called as special majority. But you do not have to worry about at this point of time where these majorities are used. But the important thing for you to understand at this stage is how to calculate a simple majority, or how the simple majority is established in what is called as a parliament. So, just note down a line as to what is simple majority, or if it is given, you can just listen to me. So, first I am going to discuss what is called as a simple majority. What is a simple majority, or how to calculate? Suppose if the constitution says for a particular purpose simple majority is required, it is to be passed by simple majority in the parliament, then how to calculate whether the simple majority is getting satisfied in the parliament or not. So, when to establish what is called as simple majority, it is the majority of the members, or if a particular proposal, suppose let us assume a proposal requires a simple majority, let us assume that is what the constitution says. Then in that particular case, the proposal has to be supported or ratified, should be ratified. Ratified means supporting it, ratified or support. Proposal should be supported by a majority of members present and voting. A proposal should be supported by a majority of members present and voting. If this condition is satisfied, then the proposal is deemed to be passed by what is called as simple majority. So, this is basically what is called as simple majority. Okay, now let me take it in the form of numerals where you can understand that better. So, what is the total strength of Lok Sabha presently? Okay, total strength of Lok Sabha is presently 543. Suppose let us assume a proposal is introduced. A proposal is introduced in the Lok Sabha. Let us assume the proposal P1. The proposal P1 is introduced in the Lok Sabha, and this proposal is to be passed with simple majority. Can you give me as to how many people have to support this to be passed with simple majority? All that you know is it has to be passed with simple majority. So, how many people have to actually support this, vote in favor of this proposal, so that we can say that the proposal P1 is passed with simple majority? What is the answer? 272, because you are saying 543 is there, 50%, more than 50% of that is 272. How many of you think that you will not be able to calculate, or the information is insufficient? Now, those who said 272, you are making an assumption that all the 543 members are present, but on a given day not necessarily everybody will be present. This is not a school, this is a member of parliament. So, not necessarily everybody will be present on a given day, even in the school there are absentees. So, therefore, the member of parliament may not be present on a given day. So, therefore, how many of you think that the information is insufficient? Okay, so now I am giving further information. The information that I am giving is, though the total membership is 543, on that particular day the number of members present is 500. So, you know this information, 500 members are present. So, now tell me the answer. 251. So, again you are making an assumption that all the members present are voting also. So, it is not necessary that the members present are voting there. So, again the information that I given is insufficient to calculate what is called as a simple majority, because what is simple majority? It is a majority of members present as well as voting. If the answer is 251, then you should also have you should also have the knowledge that all the 500 members are participating in the voting. Then you can say yes, simple majority is 251, but we are not sure that how many are voting, and that information I have not given. So, you cannot make that assumption. So, now I am giving another information that of the 500 members present, only 400 are voting. Though 500 members are present, how many are actually taking part in the voting? 500 members can also take part in the voting, that we are not sure. But let me, for the purpose of calculating the simple majority, I am just giving, though 500 members are present, how many are actually participate in the voting? 400. So, now calculate the simple majority, 201. That means this is the easiest majority that can be achieved, a majority of the members present as well as voting. That is why the name what is called as simple majority. So, therefore, in the constitution, wherever it is mentioned simple majority, we do not have to remember where for all the purpose simple majority is required at this stage. But in the later stages, I will tell you that this is a case where it requires a simple majority. So, for example, to pass an ordinary bill, it requires simple majority. So, now you should be in a position at that point of time to understand as to what is simple majority. There I will not explain you as to what is simple majority again. Is it clear to all of you how to calculate the simple majority? So, simple majority is always calculated based on the number of members present as well as voting. Unless and until you know the number of members present and voting in the house, you will not be able to calculate what is called as the simple majority. Is it clear to all of you? So, suppose again I give you, in the Rajya Sabha also the proposal needs simple majority. In the Rajya Sabha, the total membership is 245. How do you calculate simple majority? Can you calculate with this information the simple majority? Not possible. So, I will give one more information that there are 200 members present. Can you calculate simple majority? It is not possible, but let me give 150 are voting. Can you calculate the simple majority? What is the simple majority? 76. Though the total membership is 245, it does not require more than 50% of that, because only 150 members are voting. So, therefore, what is the simple majority? A majority of the members present as well as voting. It should be more than the members present as well as voting. Therefore, in this case it is just 76, and in this case what is the majority? It is just 201. So, this is how you calculate what is called as a simple majority. Is that clear to all of you as to what is simple majority? Now, wherever the constitution says it requires simple majority, this is the way by which we calculate simple majority. Shall we move forward? Is there any doubt in this calculating simple majority? Anybody has got a doubt? Because now try to understand this, because later you will have confusions if you do not understand at this stage. Is the simple majority clear? Now write down the next majority, that is absolute majority. Absolute majority. So, if it is not given, you can take down one line. If it is written, you can just note it from there itself. What is absolute majority? It is a majority of the total membership of the house. I am repeating it again. What is absolute majority? It is a majority of the total membership of the house. So, that means to calculate the absolute majority, what information that you need? All that you need is only one information as to what is the total membership of the house. You are not concerned about how many are present and voting. That is unnecessary to calculate what is called as absolute majority. Irrespective of how many members are present, irrespective of how many members are voting, that is not mandatory, but it should always be absolute majority. That is a majority of the total membership of the house. That means, say for example, to calculate the absolute majority, only one information is sufficient. I am saying that the total membership of Lok Sabha is 543. If I say that the total membership of Lok Sabha is 543, what is the absolute majority in this particular case? 272. And this is always only one majority in case of Lok Sabha and Rajya Sabha, unless until the total membership increases or decreases, which can be done only by a constitutional amendment. So, and in case of Rajya Sabha, what is the total membership? It is 245. And what would be the absolute majority in case of Rajya Sabha? In case of Rajya Sabha, it is 123. So, this is the only information that you need to calculate what is called as the absolute majority. It is a majority of the total membership of the house, not the maximum membership. Presently, what is the total membership? So, in that you will calculate what is called as absolute majority. So, the only information to calculate the absolute majority is what? Is that you need to have the information of the total membership, and if you have that, you can identify. Suppose let us assume on a given day proposal P2 is introduced. Let us assume proposal P2 is introduced in the Lok Sabha, but the number of members who is present is only 250. Let us assume only 250 members are present in the Lok Sabha. Can it be passed with absolute majority? There is no possibility it can be passed, because it needs a support of how many people? At least 272. So, therefore, at least minimum 272 members have to be present, where all the 272 members support it. Then only it is said to be passed with what is called as absolute majority. So, therefore, how many members are present and voting is not material, but minimum these many members have to support that. That is more than 50% of the total membership of the house. Then you can say it is passed with absolute majority. Now, come to the third type of majority, that is effective majority. Effective majority. So, what do you understand by effective majority? So, you can write down one line if it is not written there. It is a majority of the effective membership of the house. What is effective majority? It is a majority of the effective membership of the house. It is a majority of the effective membership of the house. That means to calculate the effective membership, to calculate the effective majority, what is the information we need to have? We need to first know what is effective membership. Without knowing what is effective membership, you cannot calculate what is called as effective majority. So, how do you calculate the effective membership? So, effective majority is nothing but the majority of the effective membership. Effective membership. And how do you calculate the effective membership? Effective membership is equal to total membership minus vacancies. So this will take us to what is called as effective membership. So the word here, vacancies, are very, very important. Now vacancies are different from what is called as absence. Do not confuse between vacancies and absence. Absence is different, vacancies is different. Can anyone tell me what is the difference between the word vacancy and absence? Vacancy, for any reason vacancy, whatever you said is right, death and disqualification, but can be other forms also. Say for example, somebody is disqualified from being a member of parliament, not only just because a member has died, not only because, what are the two things that you said? Death, disqualification you said. It can be other forms of things also. Say for example, somebody is absent in the house continuously for a long period of time, then also they can be disqualified. So then that is also ground for their disqualification. So therefore try to understand any form of vacancy. Sometimes the member, nobody has been chosen as an elector from that particular constituency. Any vacancy in the house is considered to be, to calculate what is called as the effective membership. So therefore let us assume that there are 543 is the total membership. Let us take the example of Lok Sabha. 543 is the Lok Sabha total membership, but let us assume there are 13 vacancies. So 13 vacancies are there. What would be the effective membership? Effective membership is 530 is the effective membership. Now calculate the effective majority. It is 266. It is a majority of the effective membership of the house. So when I use the word majority, it should always be more than 50%. So therefore try to understand, to calculate the effective majority, we need only one information. What is the information? We need to know what is the effective membership. And for understanding and to calculate what is the effective membership, we need to know the total membership minus vacancies. We are not concerned about how many are present as well as voting and all those things. The only case where we need to know the number of members present and voting is to calculate the simple majority. The only information we need to calculate what is called as absolute majority is the total membership. The only information that we need to calculate effective majority is the effective membership, that is total membership minus vacancies. But under one circumstance, both the effective majority as well as the absolute majority is the same. When do you think that both are one and the same? When the vacancy is 0. When the vacancy is 0, absolute majority and the effective majority is one and the same. Okay, so try to have all those things. The last thing is what is called as a special majority. So special majority, there are different types of special majority, which I will do it in the next class. But apart from these three majorities, all the type of majorities are denoted by a common name. What is that name? Special majority. That is, apart from simple majority, effective majority and absolute majority, any other type of majority is only called as special majority. But unlike these majorities, there are different types of special majorities. Tomorrow we will try to understand these special majorities and what are the different types of special majorities. Is it clear to all of you till this point of time? Alright, so with that we are coming to the end of the lecture number 3. So tomorrow once we come, I will try to complete the special majority. It will take me around 15-20 minutes to complete the special majority. First 5 minutes probably I will take up doubts if you have any doubts. So after half an hour, I will do the historical underpinnings. Again, I would say very, very important topic in the sense that mostly the students preparing for civil service examination, they will leave this area because it is not a very easy area. But I will try to simplify this particular area, try to listen to it properly. Okay. So historical underpinnings tomorrow and day after tomorrow. It will take me 2 classes to cover the historical underpinnings. So one I will try to cover the company rule, and then I will try to take up the ground rule, where I will try to cover it. And once we are done with that, then we will go into the subject polity. Probably then only I will start the Constituent Assembly, and then further I will go on to the preamble to the Constitution of India. But however, all these things are also very important. 1 or 2 questions are definitely likely to come from these areas also. Alright, so with that I will wind up the class for today. Any doubts before I wind up the class? Last couple of minutes. Ready to leave? Wanted to leave? Okay, so do you have any other class apart from this? Anybody? Anybody doing their optional after this? Okay. Here or somewhere else? Not here. So you'll have to go and attend the optional. Okay. Alright, so any questions? No questions? Okay, try to revise all these things before you come to the next class, because why I am stressing on the revision is revision is going to make your job easier, and revision is the only way that you can retain it for a long period of time. Alright, so with that I will end up the class. We will meet again tomorrow. Thank you very much.